ವಕಾಲತ್ ಸರ್. No, earlier occasion it was not there. ಓದುವಾಗ ವಕಾಲತ್ ಹಾಕಿದ್ದೇನೆ ಅಂತ ರೆಸ್ಪಾಂಡೆಂಟ್ ವೆರಿಫೈ ಮಾಡಿ ಇಮಿಡಿಯೇಟ್ ಕಂಪ್ಯೂಟರ್ 2 hours ಬಂದ ಕಸ್ಟಮರ್ ಮೇಡಮ್ ಇಷ್ಟು ಫರ್ದರ್ ಇಯರಿಂಗ್ ಯಾರು ಬಂದಿಲ್ಲ ಏನು ಓದಿಸ್ವಾ ಅಲ್ಲೇ ಹಾಕಿಲ್ಲ ಅದ್ರಲ್ಲಿ ಬರೀ ಇದಷ್ಟೇ ಅಲ್ಲ ಅದು ಕೊಡೋಷ್ಟಿಲ್ಲ ಫ್ರೆಂಡ್ಸ್ ಒಂದು ಸಮಯ ಫ್ರೆಂಡ್ಸ್ ಕೊಡೋಷ್ಟಿಲ್ಲ ಫಸ್ಟ್ ಟೈಮ್ ಸಿಗುತ್ತೆ Any memos?
Withdrawing? Yes. 230. Withdrawal then? Yes.
230. Kindly wait. Any adjournment? List 2, page 8, serial number 55 and 56.
Yes. Counsel for the petitioner prays for time to report settlement. Yes. Seven prays for time.
Gopi.
Yes.
List 1, page 1, non-compliance of office objection for first time. Serial number 1, Rennie Sebastian.
Prays for time. Yes.
2, Syed Ahmad.
Yes, 1 week's time is granted. Next. Second allow.
Syed Ahmad.
ಇಲ್ಲ absent no representation. ಅದು full ಬರ್ಕೊಳ್ಳಿ. Next.
3, Naveen Kumar Api.
Absent no representation.
4, Shankar HS.
Absent no representation.
5, Mridula.
Praise time. Next.
Pushpa TS. 6.
Absent.
7, Ravi Kumar KN.
Absent.
8, Parmeshwar Enegde.
Absent.
9, Sushant Venkatesh Pai.
My lord, appear for the appellant, my lord. Kindly grant 3 weeks time.
10, Lakshmish G.
Absent.
11, Bhaskar Babu.
Absent.
12, Chetan B.
Praise time.
11, Bhaskar Babu.
ಯಾವುದು?
Serial number 11.
11 ನಲ್ಲಿ praise for time. Next. 13.
12, 13, KS Ponnappa.
Absent.
14, Varalakshmi P.
Absent.
15, Keshav Bhatia.
Absent.
16, Varalakshmi P.
15.
By an institution, but the person who represented the institution.
What is the objection? What is the objection?
Name is not carried. Chief executive officer, the old officer has retired. A new officer has come.
There are other 2 objections.
That is also going to produce a letter. That's what. From the society again saying that often correction. But it is the routine course.
Heard on counsel for the petition, appellant, on office objection at serial number 1 to 3. When counsel for the appellant submits that the appellant is a society.
Yes. Cooperative.
Cooperative society, and therefore the office objections are to be ignored. In the light of the submission made by the learned counsel for the appellant, considered the office objections, the same are ignored. Yes. List for orders. Yes.
Serial number 16, P. Varalakshmi.
Absent.
17, Veena TN.
Praise time.
Non-compliance for second time. Serial number 18, Government Advocate. Government Advocate.
Praise for time. Next.
For order, serial number 19, Iremated Maheshaya Rudraya.
Already paid? Where is the acknowledgement? Produce that, sir. Pass over.
Serial number 20, L. Sudarshan.
Pass over.
Serial number 21, Vijay Kumar TM.
Penalella. Counsel for the appellant is absent, no representation. PF is not paid for issuance of notice to the respondent. List to finally as elections. Next.
Serial number 22, Government Advocate.
Returned answered with an endorsement that he is not found in the said address. The notice issued to respondent is returned answered as not found in the said address. When a DCCP prays for issuance of bailable warrant, as the respondent is evading service, hence issue bailable warrant. For rupees 25,000. Yes,
Serial number 23, Vidya S.
not available in the counsel for the appellant is absent, no representation, list down.
24, Ken Puttagowda. In this matter.
Lordship, since K.N. Puttagowda is not the panel counsel, kindly change the name to K. Prasanna Shetty, my lords.
Have you filed the memo?
Well, we'll file today, my lords.
Then counsel Shri Prasanna Shetty submits that he undertakes to file wakalat for the appellant. Hence office is directed to show his name of the appellant in the cause list and delete the name of so and so, who is said to be not in the panel of the appellant. Yes. As per the police report, respondent number 1 died on 23/1/2019 when the matter was still pending before the trial court. Counsel for the appellant waits for time to take steps. List down. Next.
Please.
Serial number 25, Ashwin S. Aladi.
It's needful done today morning. Needful is done.
Counsel for the appellant publish that needful is done. If necessary copies are furnished, issue notice to respond.
Please,
Yes.
Same in serial number 26. Ashwin S.
26, please, need.
Yes.
27, M. Sharas Chandra.
Yes, my lords.
As per police report, the notice sent to the respondent is returned unserved as refused. Service is held sufficient. Respondent called out absent. Office must. Place for orders. Next.
Serial number 28, YT Abhinay.
Counsel for the appellant is absent, no representation. Next.
29, Girish Kodgi.
Absent, no representation. Next.
30, Nagarajulu Naidu.
Yeah, appear for appellant in this case, my lords. Any bailable warrant may be issued, my lords.
Counsel for the appellant, no notice sent to respondent number 1 and 2 returned unserved as they are not found in the given address. Counsel for the appellant submits that the respondents are deliberately evading the service of notice and prays for issuance of bailable warrant. Submission is placed on record. Issue bailable warrant against respondent number 1 and 2 for rupees 25,000 each. You know, what is this respondent number 1? What is his address?
My lords, it's the company, we are ready mixed concrete. It's the
But you
company
have not stated that it is a company.
authorized by, represented by authorized.
No, you have not described it as a company. We are ready is a person or a company?
I'll verify, my lords. According to me, it's a company, my lords. We are ready
Wait a
mixed
minute.
concrete is a company.
Counsel for the other evading service adenu beda. Returned answered as not found in the address. Counsel for the appellant prays for time.
Please,
You clarify that.
please.
Next.
Serial number 31, K. Chandrasekhar.
For the appellant.
Not
Notice
for-
avoid ಮಾಡಿ.
Hmm?
Intentionally avoid ಮಾಡ್ತಾ ಇದ್ದಾರೆ notice.
ಅದನ್ನ ಮೊದಲು ಹೇಳಿದ್ದನ್ನು ಇಲ್ಲಿ ತಗೊಳ್ಳಿ. Intentionally avoiding issue BW for rupees 25,000. Yes, next.
32, Jagdish HT.
Appellant kindly pass out.
Pass over.
33, Shivakumar P.
Counsel for the appellant is absent, no representation.
34, Manjunath BR.
Represent the appellant. 2 days time may be granted.
Pass over, pay it, sir.
35, Vishwanath Kanavi.
Counsel for the appellant is absent, no representation. Next.
List 2, serial number 1, Mithun GA.
the respondent. I filed wakalat. I also filed an application to recall.
Filed wakalat for respondent. When?
I filed it on
7th November, my lords.
So and so filed wakalat for the respondent. He also filed an application to recall the NBW issued against the respondent. Counsel for the appellant has no objection to allow the
Yes.
application. Once the application is allowed, NBW issued against the respondent is recalled. Next, appeal is of the year 2012.
Yes, ma'am.
When will you address the argument? Both of you. Next date of hearing, both of you should be ready.
Yes, my lord. Please.
Both the learned counsel undertake to address their arguments on the next date of hearing without fail. Submission is placed on record list finally as a last chance. ಅದು recall NBW recalled ಆದ್ಮೇಲೆ send intimation to the jurisdiction police. Yes, date ಕೊಡ್ತಾರೆ. On that day, please get ready.
Yes.
Obliged.
Final hearing, for final hearing, finally as a last chance. Next.
Serial number 2, Girish PS, KP Jaisimha.
For responding to my lordship. Warrant was executed and the accused in judicial custody, my lordship, since 4 days.
Yes,
Uh,
you are ready?
lordship. I am ready, my lordship. And I filed application for recalling, my lordship.
Execute ಆಗಿದೆ sir, ಈಗೇನ್ recall?
Recall the NBW.
That is already executed. What is to be recalled? Now
It-
warrant is not pending. It is already executed.
Bail, I filed bail application, my lordship.
Pass over.
And person.
Serial number 3, Government Advocate Kushalappa.
Respond number 1, my lord.
Notice sent to R2.
Lord, he's not in. He's in abroad, my lord, the accused LOC is issued, my lord.
What is to be done? He is absconding.
Yes, my lord.
LOC is already issued.
Yes, my lord.
ಏನ್ ಮಾಡ್ತೀರಿ?
Maybe heard on merits, my lord.
Merits in the absence of responding. ನೋಡೋಣ, I will hear.
It may be listed for hearing, my lord.
No, if you can address the argument today, I will pass necessary orders. Noting this.
Kindly pass over, my lord.
Pass over.
Hearing on IA, serial number 4, Government Advocate.
Delay 83 days delay, my lord.
Heard learned counsel for the heard learned HCP, ಅದೇ ಇದೆಯಲ್ಲ, regular fact. IA is allowed, delay condoned. List for admission. Next.
Serial number 5, AL Parshuram.
IA is allowed, leave is granted, admission.
6, PI Sammati.
Heard learned counsel.
Appear for appellant, my lord.
1 and 2 allowed, leave is granted, delay is condoned. List for admission.
7, D Nagaraj Reddy.
Absent, no representation. IA allowed, leave is granted, delay 21 days, condoned. List for admission.
8, Uday Shankar.
I prefer the appellant, my
Heard
lord.
learned counsel for the appellant, leave is granted. List for admission.
9, VB Ravi Shankar.
This application will be heard along with merits.
Merit.
Notice
has to go to the.
No, make out a ground for admissions. Since there is inordinate delay of 832 days in preferring the appeal, IA 1 and 2 of 2023 are ordered to be heard along with merits. List for admission, list for call for trial court records.
10, Harish Kumar MC. 261 days.
ಇದು ಹಾಗೆ, same. Same, admission along with applications.
11, Ananta Padmanabha GN.
Heard, IA is allowed, leave is granted, list for admission. Next.
12, BS Sachin.
Hearing for the appellant.
Counsel for the appellant, IA is allowed, delay of 11 days condoned, leave is granted, list for admission.
13, Venugopal K.
Appellant in this case.
Heard. IA is allowed, delay condoned, leave is granted, admission.
14, Bharti M. 120 days.
For appellant in this case.
Why there is delay of 112 days?
I filed the delay application.
Hmm?
You filed the delay application.
Why? What is the reason? You have to open your file, look at the application and the affidavit, and make your submission.
My lord, it may be passed or not.
Pass over.
Serial number 15, Girisha HM. 36 days delay, ma'am.
Absent, no representation, I is allowed. Admission.
Serial number 16, Santosh Kumar MB.
Declare for the appellant in this case.
Just for admission.
17, Chandrakant R. Gowli.
Absent, no representation, I is allowed. Just for admission.
18, Nanjunda Gowda MR.
Third, I allowed. Leave is granted. Admission.
19, Rayappa Adagali.
Third, I allowed. Leave granted.
20,
Admission.
Onkara KB.
For the appellant, my lord.
I is allowed. Delay condoned. Leave is granted. Admission.
Grateful.
21, Bharti M.
Absent, I is allowed. Delay condoned. Leave granted. Admission.
22, Karthik Tayur.
Not for the appellant, my lord. Third, I allowed. Delay condoned. Leave granted. Just for
23.
admission.
Ravishankar RH.
Third, I is allowed. Delay condoned. Leave granted. Admission.
24, PN Harish. 322 days delay, ma'am.
Delay there, along with merits. I list for admission along with.
25, Raghavendra MN. MN Raghavendra.
Absent, I is allowed. Delay condoned. Leave granted. Admission.
26, Sagar G. Nahar.
You are for the appellant.
Please, my lord.
Third, I is allowed. Admission.
27, BT Mohan.
Oblige, my lord.
Third, is allowed. Delay condoned. Leave granted. Admission.
28, P. Prasanna Kumar.
I appeal for the
Third,
appellant. my lord.
I is allowed. Leave granted. Admission.
29, RB Deshpande.
Third, I is allowed. Leave is granted. Admission.
30, Alesha RG.
Same. Admission.
31, Vijay Kumar K.
Absent. I allowed. Admission.
32, Murgesh V. Charity.
Third, I is allowed. Leave is granted. Admission.
33, J. Sharat Chandra.
Third, I is allowed. Leave is granted. Admission.
34, same, Sharat Chandra.
Same. Same.
35, K. Srihari.
Third, I is allowed. Delay condoned.
21
Wait
days.
for admission.
36, Nishit Kumar Shetty.
Absent. No representation. I is allowed. Delay condoned. Leave granted. Admission.
37, Manjunath G. Kandekar.
Allowed. Absent. Allowed. Admission.
38, Suresh Chotanandya.
For the appellant, 42 days delay is there.
I is allowed. Delay of 42 days condoned. Leave granted. Admission.
39, Raghu Prasad BS.
Absent. No representation. No delay. Delay 228 along with merits.
40, Vishwas G. S. Reddy.
Absent. No representation. I allowed. Leave granted. Admission.
41, Shruti Chaganti.
Third,
There's a delay of 43 days.
delay condoned. Leave granted. Admission.
Please,
42, RB Deshpande.
Along with merits. A will be heard along with merits.
43, Anirudh Chamunda.
Absent. No representation. A is allowed. Delay condoned. Leave granted. Admission.
44, Rakshit Kumar.
Absent. No representation. I is allowed.
45, Mohammad Arun Rashid.
On behalf of the appellant in this
I
case, my lord.
allowed. Leave is granted. Admission.
Please, my lord.
46, K. Chandrasekhar.
Third, I allowed. Leave granted. Admission.
47, Kiran VR.
Absent. No representation. I is allowed. Delay condoned. Leave granted. Admission.
48, A. Sampath.
Absent. No representation. I allowed. Leave granted. Admission.
49, Maruti Venkatraman Ganapati.
Absent.
I am for the appellant.
Third, I allowed. Leave granted. Admission.
50, Madhu MT.
Absent, no representation. IA allowed, leave granted, admission.
51 case Bhimaya.
For appellant.
Heard, IA allowed, leave granted, admission.
52 Syed Akbar Pasha.
Appear for appellant.
Heard, IA allowed, leave granted, admission.
53 K Ravi Shankar.
Absent, IA allowed, leave granted.
For further argument, serial number 54. Prasanna Kumar.
I
HN
appear for the
Vasudev.
petitioner in 6885. State my lords had sought time last occasion to file their statement of objections.
The last time, I think everyone already completed their arguments. Pass over. Pass over.
Great.
Yes.
For final hearing, serial number 55. HK Timegowda, KV Shivareddy.
Further hearing will get continued. ನೋಡೋಣ ಪಾಸ್ ಓವರ್ ಮಾಡಿ 13 ಇದೆಯಲ್ಲ.
Serial number 56. KV Narasimhan, Prashant UT.
ಪಾಸ್ ಓವರ್.
For admission, serial number 57. Surendra Kumar N.
ಕೊಡಿ ಏನಾಗಿದೆ. ಪಾಸ್ ಓವರ್.
58. Shams Ahmad Patan. M. Krishnamurthy.
ಇದು ಪಾಸ್ ಓವರ್.
59. Kavita D.
Kindly pass.
You moved the memo for listing.
Yes, sir.
Yes, you should be
Senior
get
is
ready.
engaging in
Please
submission.
ask him to come. There are no other matters. I will take up him. Immediately, I will take up. Please ask him to come.
Yes,
60. Hariprasad MB.
she came.
Yaru,
59. 59.
60,
59. For the appellant in serial number 16.
60, yes.
My lords, this matter pertains to section 138 of Negotiable Instrument Act for the sum of rupees 6,50,000.
Good evening.
And I have challenged the acquittal order of the trial court passed in CC number 1458 of 22.
One minute,
Dated
one minute,
24
one
for
minute.
2020.
Be slow. I
Please.
have to follow your submissions.
Please, ma'am, please.
You are for the complainant.
Please, my lords. Before the trial,
Accused is acquitted
please, ma'am,
for 138 of NA Act.
please, ma'am.
Why he was acquitted?
My lords,
Say the
in this
reason for that.
matter, actually the check was admitted by the accused and signature on the check is also admitted by the accused, my lords. Though, my lords, in these circumstances also, he is acquitted from the trial court, my lords.
Why?
My lords, kindly come to page number, my lords, may I make one more submission, my lords? There is one more connected matter, my lords. In that connected matter, the coordinate bench of this honorable court has already granted special leave application also, and notice has been issued, my lords, in this matter.
Make out a ground. It is an opportunity for you to address the argument. You have to avail that.
Please, my lords.
You cannot choose the shortcut methods. What is the reason assigned by the trial court to acquit the accused?
My lords, kindly pass over. I'll only make the submission, my lords.
When you move the memo for listing, you should come prepared.
Please, my lords. I apologize for that.
Don't follow the procedure adopted by the senior counsel. You are not a senior counsel. You are a RAS junior, right? You should come prepared always.
Kindly pass over, my lords.
Serial number 61, Arjun. List three,
ಸ್ತ್ರೀ ಯಾರು ಬರಲ್ಲ ಇವತ್ತು ಇವತ್ತೇನೋ ಇಲ್ವೇ ಇಲ್ಲ. ಕರೆಕ್ಟ್, ಬಟ್ ಇವಾಗಲೇ ಬಂತಲ್ಲ ಈಗ ನೋಡಲ್.
list
Ah.
three, serial number one, non-compliance of office objection for first time,
Observe representation.
inter-alia. Non-compliance for second time, serial number two, M. Krishnegowda,
Observe no representation this time.
orders first time matter, serial number three and four,
SCGP to take notice for respondent, private respondent is the issue notice. Notice.
serial number five, A. N. Radhakrishna.
ಇದರ ಎಸ್.
ನಾನು ರೆಡಿ ಇದ್ದೀನಿ. ಸ್ನೇಹಿತರ ಹತ್ರ ಫೈಲ್ ಇಲ್ಲ ಅಂತ ಬಿಟ್ಟಿದ್ದೀನಿ. ನಾನೇನು ಹೇಳಲ್ಲ.
ಅವ್ರ ಹತ್ರ ಫೈಲ್ ಇಲ್ಲ ಅಂತ.
ಇಲ್ಲ ಅಂತ ಅದಕ್ಕೆ
ನಿಮ್ದೇ
ನಾನು
ಫೈಲ್ ಕೊಡಿ.
ಕೊಡ್ತೀನಿ ಸುಮ್ಮನೆ ಕೊಡ್ತೀನಿ.
ಸರಿ ನೋಡೋಣ.
ಅಲ್ಲವ್ರಿಗೆ ಹೇಳಿ
ಕಾಂಪ್ಲಿಕೇಟೆಡ್ ಇದ್ರೆ ಐ ವಿಲ್ ಅಡ್ಜರ್ನ್.
ಸಕ್ಸೆಸಿವ್ ಬೇಲ್ ಪಿಟಿಷನ್.
Who is the petitioner?
A2.
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 In all, how many accused?
Now there are 3 accused.
What about 1 and 3?
1 and 3 Telecast, they are in custody. So far as A1
All
is
are in
concerned,
custody.
all are in DSC. Date of offence is 23/7/20 22/7. Successive.
When he was arrested?
Applied on 21/12/23.
23.
21/12/23. He is in,
Because offense alleged.
he is in custody. 302, 201.
Earlier your petition was dismissed.
ಆಮೇಲೆ with permission, ನನಗೆ ಮೊದಲು ಗೊತ್ತಿರಲಿಲ್ಲ. It appears it has been dismissed.
Dismissed on merits.
Merits.
ನಾನು ಹೇಳ್ತೀನಿ. For that reason only it has come before this on before. It seems it is during investigation, your lordship has rejected the bail application filed by the petitioner.
Do you have the copy of the earlier order?
ಇಲ್ಲ ಸ್ವಾಮಿ ಅದೇನು.
ಇದನ್ನ ಕೊಡಿ ಅವ್ರಿಗೆ. ಅವ್ರು ಒಂಚೂರು ಓದ್ಲಿ ಆಮೇಲೆ ಹೇಳಿ.
Apart from that, my lad, ಒಂದೇ ಒಂದು ನಿಮಿಷ. One submission, my lord. Firstly, my lord, case is based on circumstantial evidence. My lord, he has no, so far as petitioner is concerned, with permission I make it. So far as petitioner is concerned, he has no intention or eliminate or any motive against the disease. Nagaraj is concerned. It is the accused number one who is masterminded person behind all these sequences.
ಇಂಟೆನ್ಷನ್ ಇಲ್ಲ ಅಂತ ಹೇಳಿ ನಿಮ್ಮನ್ನ ನಿಗಾಮುಗ ಸ್ಟಾಬ್ ಮಾಡಿ ಕೊಂದು ಬಿಟ್ರೆ
Stab
that is not enough.
Stab alla, according to my, with great respect, there is a serious allegation against my client.
Yes,
I'm not disputing.
that is why I
It-
gave
it-
it to you.
ಅಲ್ಲ ಸ್ಟಾಪ್ ಅಂತಾನು ಮತ್ಕಿಂತಲೂ ಕೇಸ್ cut the throat of the
Both
neck-
accused
neck-
number 1 and
neck
2 strangulated the neck.
strangulated and
And
that is
thereafter,
that is based on circumstances.
yes. yes.
That and one more circumstance is admittedly, as I submitted, case is rest on circumstance. First accused number 1 was arrested
Hmm.
on 20th of
Hmm.
then he was arrested.
Yes.
The petitioner, based on the confessional statement of accused number 1, he has been fixed.
Not only that, sir.
Mala,
The knife used in commission of the offense is recovered at your instance.
subsequent recoveries will let's make kindly
Sir,
take.
recovery will
I will-
play
I will come-
very
I will
important
come to
role.
that, I will come to that. Let's me kindly take into consideration, Evan is the person who is behind all these things. Only on 20, on that, the fateful day, he met this person. Met this person. And earlier to that, he has instructed, he has requested to supply that Kudre Katala, Pujigoskara, black magic Madagoskara. Avranalli idukoskara, for his lust and misdeed, he has made use of this accused. And so far as that submission, my lord, with permission, observation that he is the only person who has committed this act, stabbed along with accused number 1 and cut the throat, Ahmadke. Admittedly, except circumstantial evidence, there is no other eyewitness. That is not supported with any of these, except self-serving say of the
Sir,
eyeball.
circumstantial witness says, I have last seen in the company of the accused. The deceased was found dead. As per PM report, the death was due to asphyxia. The dead body had stabbed injuries, multiple stabbed injuries. The blood-stained knife was recovered at your instance. Will it not complete the circle, complete the chain? Time of AC.
So far as bail is concerned, my lord, my response submission, my lord, it appears to be, I'm not disputing,
Hmm.
it appears to be, but the degree of the offense, degree of the gravity, let's just make kindly consider. It is only the accused number 1, who is the police officer, instead of leading his life with his wife, who made use of this innocent.
You are not a child, sir. You are aged 42 years.
Even then, my
You
lord,
should have sense before doing any act.
there is no, earlier, they have not criminally conspired.
Maybe.
Suddenly it took him, suddenly
Maybe
it took.
It is not as if you are a juvenile.
No,
You are a grown-up adult, aged 42 years,
That
at
is
least 40 years when the incident had occurred.
Even then, my lord, let's me kindly consider so far as
You
this.
cannot blame accused number 1 told, so.
I am
the
not
incident-
blaming, I am not blaming. He is the mastermind for his lust.
Now, what is the stage? What is the stage before the trial court?
And charge sheet is filed and
Charge sheet earlier filed.
committed and. stayed.
You have not asked for framing of charge. Since all the 3 are in judicial
That is
custody,
correct.
how many witnesses are there?
Like that. One second. In all, 66 witnesses.
Hmm.
66 witnesses.
ಅಷ್ಟೇ ಎಲ್ಲ ಫಾರ್ಮಲ್ ವಿಟ್ನೆಸಸ್ ಇರ್ತಾರೆ.
ಏನೇನ್ ಫಾರ್ಮಲ್ ಏನಲ್ಲ, ಕಷ್ಟನೇ
Formal
ಇರ್ತೈತೆ.
ಫಾರ್ಮಲ್ ಇರ್ತಾರೆ, ಕೆಲವರಷ್ಟೇ
ಅಲ್ಲ, of
material
course.
witnesses. No, not a case for grant of bail.
I leave it to this.
Yes. Yes,
Maybe-
what do you say?
I may be permitted to, then I may be permitted.
It will not change. If this petitioner is to be granted bail, all the 3 is to be granted bail.
No, with great respect, with little bit, my lord, the gravity of the offense,
Yes,
who is behind masterminded before the back of this.
mastermind and the assailant, actual.
According to prosecution, he has
Yes.
participated, I am not disputing. But
prima
masterminded
facie
fellow
fact.
is, it is,
Yes.
because of his
You
bad
are
misdeeds.
withdrawing it?
My lord,
You are withdrawing
I am
or?
trying.
Yes, counsel for the petitioner after addressing the argument for some seeks permission to withdraw the petition. Submission is placed on the memo hakidre memo dismissed as withdrawn.
Number 6, Chakravarti TX.
Hearing for the petitioner. Present petitioner is the A6, my lord.
A6. A6.
A6, my lord. A2 and A8 already
So
granted.
in all, how many accused? Okay. ನಿಮ್ ಫೈಲ್ ಏನು ಮೇಂಟೈನ್ ಮಾಡಲ್ವಾ?
Same crime,
ಇದು ಏನು ಇದ್ರದ್ದ?
canning,
ಹಾ?
PT Act,
ಅದು ಯಾವ್ದು ಇದ್ರದ್ದು ಎಲ್ಲಿದ್ದದು? ಯಾವ?
ಭ್ರೂಣ ಹತ್ಯೆಗೆ. ಪಾಂಡವಪುರ,
ಪಾಂಡವಪುರ.
2 and 8 already granted there. 6.
ನೋಡ, let her get the file.
Maybe taken up tomorrow.
Monday,
Council for HCGP praise for time and council Leonard HCGP praise for time. This time, Monday, Tuesday, our note. Yes.
Serial number 7, Arjun.
ಆಗೋಯ್ತಿಲ್ಲ 11 ಗಂಟೆಗೆ. ಇದನ್ನ ಯಾರು ಬರಲ್ಲ. ಸೆಕೆಂಡ್ ಇಸ್ಕೊಂಡು ವೇಟ್ ಮಾಡ್ಬೇಕು. ಇಲ್ಲ, ಮೊನ್ನೆನೇ ಹೇಳಿದ್ರಲ್ಲ ಅವರು, ಅವ್ರು ಹಾಕಿದ್ರೆ ಸ್ಟೇಟ್ಮೆಂಟ್ ಆಫ್ ಅಬ್ಜೆಕ್ಷನ್ ಹಾಕಿದ್ರೆ ನಮಗೆ ತಗೊಬೇಕು. ಯಾರು ಇಲ್ಲ.
Anybody is ready in the matter? Serial number, ma'am? 59. 59.
List number?
List number 2, my lord.
Yes.
My lord, it is a case of acquittal, case of 138 Act, my lord. The check amount is 3,95,000.
ನೋಟಿಸ್ ಆಗಿಲ್ಲಲ್ಲ? Yes, 138 NI Act.
NI Act, my lord. The check amount is 3,95,000.
Yes.
Here on 2 grounds, my lord, this complaint has been dismissed. One ground is, my lord, the 2,95,000 is transferred complainant from the accused account. Remaining amount 1,01,000 has been paid by cash. It has been clearly shown in the reason, whatever the mention in order, my lord, in page number 30, order page number 13, my lord, 13. They have clearly said that why the complainant has transferred 2,95,000, why not 1,01,000 she has?
So you mean to say the trial court has not accepted your contention that you have lent rupees 3,95,000?
Yes, my lord.
Right?
One ground. And second ground, my lord, here the complainant and complainant husband has disputed in between them, my lord. It is a family problem. The accused statement is that accused has transferred and paid cash to the complainant husband, and he has given evidence in against complainant. Accused complainant husband has given
Your husband has deposed?
Yes, my lord. It is also clearly mentioned in page number 17 of the order, my lord. And one more ground is, my lord, the complainant advocate is not cross-examined the husband of the complainant. On these 3 main grounds, the
Husband of complainant is examined as DW?
2.
You have not cross-examined?
No, my lord.
Then is it not fatal?
No, my lord, because I'm having dispute between
Maybe.
my
maybe
husband, my
having,
lord. He is not coming from past 3 years to my house.
Maybe what may be the justification for not cross-examining the witness? That means you accepted his say.
No, he was not having communication. So many
Maybe-
other internal problems were there, my
You
lord.
may be having 101 problems.
Yes,
But that cannot be the justification for not cross-examining the witness.
that is the main.
What is the position of law when the witness is not cross-examined?
It is a presumption, assumption has to be taken.
You admit whatever the witness say, you have nothing to cross-examine.
I have stated in my cross-examination, I don't have any problem to
Maybe-
cross-examine the DW2. But
You have not cross-examined.
not cross-examine, my lord.
Yes,
That is
sir,
the
that is
only main
fatal.
ground, my lord. But check and signature and the 2,95,000, whatever the transfer that has been admitted by the accused, my lord.
that all those things was not considered by the trial court.
What DW2 says,
In page number 17, my lord, that is the ink page number 34. Ink page number 34, order page number is 17, my lord. It used to be
What is-
noted. Yes, my lord.
Srinivas,
Srinivas, my lord, got examined and DW who has given evidence in his examination chief in support of the case of the accused. However, DW2 did not tender for cross-examination. He was not tendered, my lord, he was not come before. That is the thing that I have not filed any application for cross-examination. He was not turned up. In complainant side also, I was not filed any application. That is the main ground, my lord. Apart from that, the check is admitted. Well within time, I have filed the complainant. Statutory notice has been served to the accused. He has not replied for that notice. All the contention has been taken by the trial court. The amount 1,69,000 is transferred to complainant husband account.
no, grounds ಇಲ್ಲ.
My lord, page number 20, my lord, it is clearly shows that he has not turned up for cross-examination. When I was ready, he was not turned up. Page number
Cannot be the
37.
That cannot be the ground for not cross-examining a material witness.
No, he has not turned up, my lord. If one opportunity has been given, I'll,
Why the application was not filed?
He
You could
was
have filed
not-
an application.
yes, my lord.
You could have requested the trial court.
Yes,
No such effort is made. Then
no, because,
nothing, ಏನು ಇಲ್ಲ.
no, other the check is admitted, my lord, the amount has been transferred to RTGS, my lord, via
Discharge.
RTGS.
Discharge.
Mm.
He has probabilized the defense. No,
One opportunity may be,
No.
my lord.
yeah, no purpose would be served.
No, because
Even if the opportunity
husband and
is-
wife problem, the wife is suffering, husband is not earning, we have filed MC petition, DV Act, so many other cases. For on that grid, he has came and favorable witness to the accused.
No.
And one more thing, he has not turned up to the, for cross-examination.
Thing.
In order clearly.
It's negligence on the part of the complainant.
My lord,
There is no explanation.
only one opportunity, my lord.
Now, why the accused is to be
Within a
served?
week, I'll establish my bona fide, my lord,
Nothing,
because
nothing. ಇಲ್ಲ, ಏನು ಇಲ್ಲ ಬಿಡಿ.
he has taken money and not only this 4 lakhs, my lord, 18 lakhs he has grabbed from the complainant and he has utilized 498 application is also pending, my lord.
No.
For-
Give me a reasonable explanation why DW2 is not cross-examined.
He has not turned up, my lord, before the court. When I was ready.
If
with
he
the-
was not turned up, the court will not say there is no cross-examination.
Yes, my lord.
The
No, in
evidence will be
in Page
expunged.
number 20, the trial court has said that he has
Thereafter?
not turned up.
Thereafter,
Thereafter also, for 3 occasions, date was given. He has not turned up. In
when
page number
order sheet
20,
dated,
ink page number 37, order
page number Allah, I am looking at the original documents. Please tell me the date. Yes, yes, it is, this evidence is closed.
Yes, my lord.
Told. Third learned counsel for the appellant. Satisfied with the grounds made out in the memorandum of appeal. Feel admitted. All for trial court records. Issue notice to so and so. Appeal admitted.
Much obliged, my lord.
Issue notice. Pay PF for issuance of notice.
Today itself I'll comply.
Yes, yes.
Serial number 56. CV Narasimhan. Prashant Duty.
ಈಗ
PF
ಆಗಿದ್ದು ಯಾವ್ದು 59 ಅಲ್ವಾ ಆಗಿದ್ದು ಈಗ 56.
56, my
On duties.
lord, arises out of the Negotiable Instruments Act, my lord, section 138.
One 38.
138, my lord, has ended in an order of acquittal. Hence, my lord, the present appeal.
Check dated
My lord, check is dated 11/9/2014
for rupees.
for a sum of rupees, my lord. There are two checks, my lord, 5 lakhs each. Totally, my lord, coming to 10 lakhs.
Same date, even date.
Same date, my lord, same date.
Dishonored as.
Dishonored as funds insufficient.
The same day both were presented.
Yes, my lord, is presented on the very same day.
Legal notice
My lord, the legal notice was issued on 9/10/2014.
served.
Served, my lord, on 16/10/2014.
Postal acknowledgement is there.
Yes, we have filed it. And even reply, my lord, is made to the notice.
What is the reply? Defense,
Defense is denial,
total denial.
total denial. He says there is no relationship between the two, has not taken the loan.
What about check?
Check, my lord, no specific defense taken regarding the check.
In the
As-
reply.
No reply, in the
Where
reply.
is the
it is not
reply?
taken. The-
Exhibit.
My lord, it is at exhibit P9, my lord.
You paid in cash.
I paid in cash.
How much?
Pardon me, 10 lakhs.
10 lakhs.
Yes.
When?
Fifteen 4/2012, my lord, is the date that I have paid.
16/4.
2012.
On demand promissory note is also there.
Please, my lord.
Whether it is produced.
No. Not.
There's a cross-examination to PW1.
Please. 15/12/2015 madam, yes, sir.
Yes,
Married.
yes.
ನಾನು 1/11/2011 ಮರ್ಕ್ಯುರಿ ಎಂಟರ್ಪ್ರೈಸಸ್ ಬಿಸ್ನೆಸ್ ನಡೆಸುತ್ತಿದ್ದೇನೆ. ಆರೋಪಿ ಕಂಪ್ಯೂಟರ್ ಪ್ರಿಂಟರ್ ಮತ್ತು ಕಾಪಿ ಮಾರಾಟ ಮಾಡುತ್ತಾರೆ. ನನ್ನನ್ನು ಆರೋಪಿ ಸಾಲಕ್ಕಾಗಿ ಏಪ್ರಿಲ್ 2012 ಮೊದಲನೇ ವಾರದಲ್ಲಿ ಕೇಳಿರುತ್ತಾರೆ. ನಿಖರವಾದ ದಿನಾಂಕ ನೆನಪು ಇಲ್ಲ. ನಮಗೆ ವಾರ್ಷಿಕ ಕೋಟಿಗಟ್ಟಲೆ ವ್ಯಾಪಾರ ಇರುತ್ತೆ. 2012 ನನಗೆ ವಾರ್ಷಿಕ ಎಷ್ಟು ಟರ್ನ್ ಓವರ್ ಇತ್ತು ಎಂದು ಈಗ ಹೇಳಲು ನೆನಪಿಲ್ಲ. ನಾವು ಆದಾಯ ತೆರಿಗೆ ಪಾವತಿಸುತ್ತೇವೆ. 2012 ನಾನು ನನ್ನ ಆದಾಯ ಎಷ್ಟು ಇತ್ತು ಎಂದು ಘೋಷಣೆ ಮಾಡಿಕೊಂಡಿದ್ದೇನೆ ಎಂದು ಹೇಳಲು ನೆನಪು ಇಲ್ಲ. ಆರೋಪಿ ₹10 ಲಕ್ಷ ಸಾಲ ಕೊಟ್ಟ ಬಗ್ಗೆ ಆದಾಯ ತೆರಿಗೆ ರಿಟರ್ನ್ಸ್ ನಲ್ಲಿ ಹೇಳಿದ್ದೀರಾ ಎಂದರೆ ಸಾಕ್ಷಿಯು ನನಗೆ ಈ ಬಗ್ಗೆ ನಮ್ಮ ಆಡಿಟರ್ ಸಲಹೆ ನೀಡಿಲ್ಲ ಎನ್ನುತ್ತಾರೆ. ನಾನು 2012 ಸಾಲಿನ ಆದಾಯ ತೆರಿಗೆ ದಾಖಲೆಗಳನ್ನು ನ್ಯಾಯಾಲಯವು ಕೇಳಿದ ಪಕ್ಷದಲ್ಲಿ ಹಾಜರುಪಡಿಸಲು ತೊಂದರೆ ಇಲ್ಲ. ಅದೇ ರೀತಿ ಆರೋಪಿ ನನಗೆ ಸಾಲ ಬಗ್ಗೆ ಬರೆದು ಕೊಟ್ಟಿದ್ದರು ಎಂದು ಹೇಳಲಾದ ಆನ್ ಡಿಮ್ಯಾಂಡ್ ಪ್ರಾಮಿಸರಿ ನೋಟನ್ನು ಹಾಜರುಪಡಿಸಲು ತೊಂದರೆ ಇಲ್ಲ. ನಾನು ಚೆಕ್ ಅನ್ನು ನಗದೀಕರಣಕ್ಕೆ ಹಾಜರುಪಡಿಸುವ ಮೊದಲು ನನ್ನ ಮತ್ತು ಆರೋಪಿ ನಡುವೆ ಮಾತುಕತೆ ನಿಂತಿತ್ತು. ಅಂದರೆ 10/9/2014 ಸಮಯದಲ್ಲಿ ನನ್ನ ಮತ್ತು ಆರೋಪಿ ನಡುವೆ ಮಾತುಕತೆ ನಿಂತಿತ್ತು. ನಿಪಿ 1 ಚೆಕ್ ಅನ್ನು ನಗದೀಕರಣಕ್ಕೆ ಹಾಜರುಪಡಿಸುವ ಮೊದಲು ಆರೋಪಿಗೆ ಮಾಹಿತಿ ನೀಡಿದ್ದೆ ಎಂಬ ಬಗ್ಗೆ ದೂರಿನಲ್ಲಿ, ನೋಟಿಸ್ನಲ್ಲಿ ಮತ್ತು ಮುಖ್ಯ ವಿಚಾರಣೆಯಲ್ಲಿ ಹೇಳಿದ್ದೀರಾ ಎಂದರೆ ಸಾಕ್ಷಿಯು ಹೇಳಿಲ್ಲ. ಆದರೆ ಅವರ ನಿರ್ದೇಶನದ ಅನುಸಾರವಾಗಿ ಚೆಕ್ ಅನ್ನು ನಗದೀಕರಣಕ್ಕಾಗಿ ಬ್ಯಾಂಕಿಗೆ ಹಾಜರುಪಡಿಸಿದ್ದೆ ಎಂದು ನುಡಿಯುತ್ತಾರೆ. ನಿಪಿ 1 ಚೆಕ್ ಅನ್ನು ನಗದೀಕರಣಕ್ಕೆ ಹಾಜರುಪಡಿಸುವ ಮೊದಲು ನನ್ನ ಮತ್ತು ಆರೋಪಿ ನಡುವೆ ಯಾವುದೇ ಮಾತುಕತೆಯಾಗಿಲ್ಲ ಎಂದರೆ ಸರಿಯಲ್ಲ. ನಾನು ಏನು ಹಣದ ಲೇವಾದೇವಿ ಮಾಡುವುದಿಲ್ಲ. 1ನೇ ಆರೋಪಿ ಸಂಸ್ಥೆ ಪ್ರೊಪ್ರೇಟರಿ ಕನ್ಸರ್ನ್ ಎಂಬುದರ ಬಗ್ಗೆ ಅರಿವು ಇದೆ. 2ನೇ ಆರೋಪಿ ಮೊದಲನೇ ಆರೋಪಿ ಸಂಸ್ಥೆಯ ಪ್ರೊಪ್ರೇಟರ್ ಅಲ್ಲ ಅಂದರೆ ಸಾಕ್ಷಿಯು ನಾನು ಶ್ರೀನಾಥ್ ಹೆಗಡೆಯವರನ್ನು 2ನೇ ಆರೋಪಿ ಎಂದು ಹೇಳಿಲ್ಲ. ಅವರು ಸಿದ್ಧಾರ್ಥ್ ಎಂಟರ್ಪ್ರೈಸಸ್ ನ ಪ್ರೊಪ್ರೇಟರ್ ಎಂದು ಅವರ ವಾಸದ ವಿಳಾಸ ಸಲುವಾಗಿ ನಾನು ಫಿರ್ಯಾದಿ ಶಿರೋನಾಮೆಯಲ್ಲಿ ಶ್ರೀನಾಥ್ ಹೆಗಡೆಯವರನ್ನು ನಂಬರ್ 2 ಎಂಬುದಾಗಿ ತೋರಿಸಿದ್ದೇನೆ ಎಂದು ನುಡಿಯುತ್ತಾರೆ. ಶ್ರೀನಾಥ್ ಹೆಗಡೆಯವರು ಸಿದ್ಧಾರ್ಥ್ ಎಂಟರ್ಪ್ರೈಸಸ್ ನ ಪ್ರೊಪ್ರೇಟರ್ ಅಲ್ಲ ಎಂದರೆ ಸಾಕ್ಷಿಯು ಆತ ಶ್ರೀನಾಥ್ ಎಂಟರ್ಪ್ರೈಸಸ್ ಅಧಿಕೃತ ವ್ಯಕ್ತಿ ಇದ್ದು ಆ ಸಂಸ್ಥೆಯ ಪರವಾಗಿ ಅಧಿಕೃತ ವ್ಯವಹಾರ ಮಾಡುವಂತಹ ಅಧಿಕಾರ ಹೊಂದಿರುತ್ತಾರೆ ಎಂದು ನಡೆಯುತ್ತಾರೆ. ನಾನು ಸಿದ್ಧಾರ್ಥ್ ಎಂಟರ್ಪ್ರೈಸಸ್ ಪ್ರೊಪ್ರೇಟರ್ ಅನ್ನು ದೂರಿನಲ್ಲಿ ಆರೋಪಿಯನ್ನಾಗಿ ಮಾಡಿಲ್ಲ ಎಂದರೆ ಸಾಕ್ಷಿಯು ನಮ್ಮ ವ್ಯವಹಾರಕ್ಕೆ ಸಂಬಂಧಿಸಿದಂತೆ ಆರೋಪಿ ನೀಡಿದ ಚೆಕ್ ನಲ್ಲಿ ಸಿದ್ಧಾರ್ಥ್ ಎಂಟರ್ಪ್ರೈಸಸ್ ಪರವಾಗಿ ಶ್ರೀನಾಥ್ ಹೆಗಡೆಯವರು ಅಧಿಕೃತ ವ್ಯಕ್ತಿಯಾಗಿ ಸಹಿ ಮಾಡಿರುವ ಕಾರಣ ನಾನು ಅವರನ್ನು ಆರೋಪಿಯನ್ನಾಗಿ ಮಾಡಿ ಈ ದೂರನ್ನು ತಂದಿದ್ದೇನೆ ಎಂದು ನುಡಿಯುತ್ತಾರೆ. ನಾನು ಶ್ರೀನಾಥ್ ಹೆಗಡೆಯವರಿಗೆ ತುಂಬಾ ಹತ್ತಿರದ ವ್ಯಕ್ತಿ ಇದ್ದ ಹಿನ್ನೆಲೆಯಲ್ಲಿ ಅವರ ಚೆಕ್ ಅನ್ನು ದುರುಪಯೋಗಪಡಿಸಿಕೊಂಡಿದ್ದೇನೆ ಎಂದರೆ ಸುಳ್ಳು. That is only, my lord, one suggestion that has been put. ನಿಪಿ 1 ಚೆಕ್ ನಲ್ಲಿರುವ ಬರವಣಿಗೆ ನನ್ನದು ಎಂದರೆ ಸರಿಯಲ್ಲ. ಅದು ಆರೋಪಿಯ ಬರವಣಿಗೆ ಆಗಿರುತ್ತದೆ. ನಾನು ಆರೋಪಿ ಶ್ರೀನಾಥ್ ಹೆಗಡೆಗೆ ₹10 ಲಕ್ಷ ಸಾಲವಾಗಿ ಕೊಡಬೇಕಾದರೆ ಗುರುಪ್ರಕಾಶ್ ಎಂಬ ವ್ಯಕ್ತಿ ಇದ್ದರು. ಅವರು ಸಾಲ ಕೊಡುವ ಸಂದರ್ಭದಲ್ಲಿ ಗುರುಪ್ರಕಾಶ್ ಎಂಬ ವ್ಯಕ್ತಿ ಇದ್ದ ಬಗ್ಗೆ ನನ್ನ ದೂರು ಮತ್ತು ಮುಖ್ಯ ವಿಚಾರಣೆಯಲ್ಲಿ ಹೇಳಿದ್ದೇನೆ. ಆ ರೀತಿ ನಾನು ಗುರುಪ್ರಕಾಶ್ ಇದ್ದ ಬಗ್ಗೆ ನನ್ನ ದೂರಿನಲ್ಲಿ ಮತ್ತು ಮುಖ್ಯ ವಿಚಾರಣೆಯಲ್ಲಿ ಹೇಳಿಲ್ಲ ಎಂದರೆ ಸರಿಯಲ್ಲ. ನನಗೆ ಅವಶ್ಯ ಇದ್ದರೆ ಗುರುಪ್ರಕಾಶ್ ರವರನ್ನು ಸಾಕ್ಷಿಯಾಗಿ ಮಾಡುತ್ತೇನೆ. ನಾನು ಆರೋಪಿಗೆ ಯಾವುದೇ ಹಣವನ್ನು ಸಾಲವಾಗಿ ಕೊಟ್ಟಿಲ್ಲ ಎಂದರೆ ಸರಿಯಲ್ಲ. ಆ ಸಮಯದಲ್ಲಿ ಗುರುಪ್ರಕಾಶ್ ರವರು ಇರಲಿಲ್ಲ ಎಂದರೆ ಸರಿಯಲ್ಲ. ಶ್ರೀನಾಥ್ ಹೆಗಡೆಯವರಿಗೆ ತೊಂದರೆ ಕೊಡುವ ಸಲುವಾಗಿ ಈ ಸುಳ್ಳು ದೂರನ್ನು ತಂದಿರುತ್ತೇನೆ ಎಂದರೆ ಸರಿಯಲ್ಲ.
Why DP note was not produced?
My lord, the point is the check, my lord, was there and there was no specific stand that was taken. So I did not comprehend anything, my lord, to think that this could be any reason. But now, my lord, the trial court doesn't say that there is no transaction or anything of that sort.
Yes.
Now, trial court goes on a totally different ground, which is not pleaded by the the accused even in the reply or in the
Reason assigned?
The reason now that is assigned is, my lord, as I now the first accused, my lord, is one Siddhartha Enterprises. It is represented by Srinath Hegde. Now the check, my lord, is issued by Srinath Hegde. Now he has represented throughout, and at no point of time, my lord, he took up a contention or even in the cross-examination that somebody else was the proprietor. Now, even during his evidence, my lord, he does not spell out who is the proprietor.
The reason assigned by
is that the proprietrix of Siddhartha Enterprises had to be made a party. Now that is not there, and hence, my lord, the order of acquittal is passed. That's the only reason that is assigned.
Why the trial court held the accused is not the proprietor?
Now, my lord, what happens is there is one document, my lord, that he produces, the accused. That, my lord, is marked as Exhibit D2.
Certificate.
It's a certificate that is stated to be issued by the bank. Exhibit D2, my lord. This is to certify that Measure Siddhartha Enterprises proprietrix Srimati Shashikala Hegde. Shashikala Hegde is the wife of the accused number 2. Is maintaining a current account with our bank from 1/1/1996. This certificate is issued so and so with the risk, etc. Now, till this time, my lord, the accused had never ever took up a contention that he is not a prosecutor. I'm so sorry. He is not the proprietor.
What is the evidence of DW1?
Please, my lord. My lord, I'll read from the examination in chief, my lord, so that I would like to point out that he had never taken this defense. Now, my lord, 24/3/2016, my lord. ಮುಖ್ಯ ವಿಚಾರಣೆ.
Yes.
ನಾನು ಬೆಂಗಳೂರಿನ ಅಣ್ಣಯ್ಯ ಪಾಳ್ಯ ಲೇಔಟ್ನಲ್ಲಿರುವ 80 ಅಡಿ ರಸ್ತೆ 1ನೇ ತಿರುವು ಮನೆ ಸಂಖ್ಯೆ 1ರಲ್ಲಿ ವಾಸಿಸುತ್ತೇನೆ. ನನಗೆ ಕಳೆದ 7-8 ವರ್ಷಗಳಿಂದ ಫಿರ್ಯಾದುದಾರರು ಗೊತ್ತು. ಅವರು ಪೀಠೋಪಕರಣ ವ್ಯವಹಾರ ಮಾಡುತ್ತಿದ್ದರು. ಅವರು ನಮ್ಮಲ್ಲಿ ಫರ್ನಿಚರ್ ಆರ್ಡರ್ ಸಲುವಾಗಿ ಬರುತ್ತಿದ್ದರು. ನಾನು ಸಿದ್ಧಾರ್ಥ ಎಂಟರ್ಪ್ರೈಸಸ್ ನ ಆರ್ಥಿಕ ಸ್ಥಿತಿಗತಿಗಳ ಬಗ್ಗೆ ಫಿರ್ಯಾದಿಗೆ ಹೇಳಿಲ್ಲ. ನಾನು 2012ರಲ್ಲಿ ಫಿರ್ಯಾದುದಾರರಿಗೆ ಕೈ ಸಾಲವನ್ನು ಎಂದೂ ಕೇಳಿಲ್ಲ. ಹಾಗೆಯೇ ಫಿರ್ಯಾದುದಾರರಿಂದ ಯಾವುದೇ ಹಣವನ್ನು ಕೈ ಸಾಲವಾಗಿ ಪಡೆದಿಲ್ಲ. ನಾನು ಯಾವುದೇ ದಾಖಲೆಗಳನ್ನು ಅಂದರೆ ಆನ್ ಡಿಮ್ಯಾಂಡ್ ಪ್ರೋನೋಟ್ ಮತ್ತು ಹಣ ಸಂದಾಯ ರಸೀತಿಗಳನ್ನು ಯಾವುದೇ ಸಾಲದ ವಿಚಾರಕ್ಕೆ ಸಂಬಂಧಿಸಿದಂತೆ ಫಿರ್ಯಾದುದಾರರಿಗೆ ಬರೆದುಕೊಟ್ಟಿಲ್ಲ. ನಿಪಿ 1 ಮತ್ತು 2ರ ಚೆಕ್ ಅನ್ನು ಯಾವುದೇ 10 ಲಕ್ಷ ರೂಪಾಯಿಗಳ ಸಾಲ ತೀರುವಳಿಕೆಗೆ ಎಂದು ಫಿರ್ಯಾದುದಾರರಿಗೆ ಕೊಟ್ಟಿಲ್ಲ. ನಿಪಿ 1 ಮತ್ತು 2ರ ಚೆಕ್ಗಳನ್ನು ಫಿರ್ಯಾದುದಾರರು ಸಿದ್ಧಾರ್ಥ್ ಎಂಟರ್ಪ್ರೈಸಸ್ ಫರ್ನಿಚರ್ ಸರಬರಾಜು ಮಾಡುವ ಸಂದರ್ಭದಲ್ಲಿ ನನ್ನಿಂದ ಸಹಿ ಮಾಡಿದ ಮೊತ್ತ ಮಾತ್ರ ಭರ್ತಿ ಮಾಡಿದ ಚೆಕ್ಕುಗಳನ್ನು ಪಡೆದುಕೊಂಡಿದ್ದರು. ಸಾಕ್ಷಿಯು ಮುಂದುವರೆದು ನಾನು ಸಿದ್ಧಾರ್ಥ್ ಎಂಟರ್ಪ್ರೈಸಸ್ ನ ಆಥರೈಸ್ ಸಿಗ್ನೇಟರಿ ಇರುತ್ತೇನೆ. ಹಾಗಾಗಿ ನಾನು ಸಹಿ ಮಾಡಿದ ಚೆಕ್ಕುಗಳನ್ನು ಸಿದ್ಧಾರ್ಥ್ ಎಂಟರ್ಪ್ರೈಸಸ್ ಪರವಾಗಿ ಫಿರ್ಯಾದುದಾರರು ಪಡೆದುಕೊಂಡಿದ್ದರೆಂದು ನುಡಿಯುತ್ತಾರೆ.
1 minute.
ಪ್ಲೀಸ್. The first 3 sentences, my lord, are of great relevance. So, my lord, issuance of the check he speaks, my lord, and he says regarding the supply of furniture he has issued. Now, third line, my lord, ಸಾಕ್ಷಿಯು ಮುಂದುವರೆದು ನಾನು ಸಿದ್ಧಾರ್ಥ ಎಂಟರ್ಪ್ರೈಸಸ್ ನ ಆಥರೈಸ್ ಸಿಗ್ನೇಟರಿ ಇರುತ್ತೇನೆ. ಹಾಗಾಗಿ ನಾನು ಸಹಿ ಮಾಡಿದ ಚೆಕ್ಗಳನ್ನು ಸಿದ್ಧಾರ್ಥ ಎಂಟರ್ಪ್ರೈಸಸ್ ಪರವಾಗಿ ಫಿರ್ಯಾದುದಾರರು ಪಡೆದುಕೊಂಡಿರುತ್ತಾರೆ ಎಂದು ನುಡಿಯುತ್ತಾರೆ. ಚೆಕ್ಗಳು ನಗದೀಕರಣವಾಗದೆ ವಾಪಸ್ಸು ಬಂದ ವಿಚಾರವನ್ನು ನನ್ನ ಪ್ರೊಪ್ರೇಟರ್ ನನಗೆ ಹೇಳಿದ್ದು ಆಗ ಫಿರ್ಯಾದುದಾರರನ್ನು ಕಂಡು ನನ್ನ ಬಾಪ್ತು ಸಹಿ ಮಾಡಿದ ಮೇಲೆ ಹೇಳಿದ ಚೆಕ್ ಅನ್ನು ವಾಪಸ್ಸು ಕೊಡುವಂತೆ ಹೇಳಿದ್ದೆ. ನಾನೇನು ಸಿದ್ಧಾರ್ಥ್ ಎಂಟರ್ಪ್ರೈಸಸ್ ನ ಮಾಲೀಕನಲ್ಲ. ನಿಪಿ 1 ಮತ್ತು 2ರ ಚೆಕ್ಗಳು ಸಹ ಸಿದ್ಧಾರ್ಥ್ ಎಂಟರ್ಪ್ರೈಸಸ್ಗೆ ಸಂಬಂಧಪಟ್ಟ ಚೆಕ್ಗಳಾಗಿರುತ್ತದೆ. ಫಿರ್ಯಾದುದಾರರು ಚೆಕ್ ಅಮಾನ್ಯಗೊಂಡ ಹಿನ್ನೆಲೆಯಲ್ಲಿ ನೀಡಿದ್ದ ನೋಟಿಸ್ಗೆ ನಾವು ನಿಪಿ 9ರಂತೆ ಉತ್ತರಿಸಿದ್ದೇವೆ. ನಾನು ನಿಪಿ 1 ಮತ್ತು 2ರ ಚೆಕ್ಗಳನ್ನು ಫಿರ್ಯಾದುದಾರರಿಗೆ ಯಾವುದೇ ಸಾಲದ ತೀರುವಳಿಗಾಗಿ ನೀಡಿಲ್ಲ. ನನ್ನ ಮತ್ತು ಫಿರ್ಯಾದುದಾರರ ನಡುವೆ ಯಾವುದೇ ಸಾಲದ ವ್ಯವಹಾರವಾಗಿಲ್ಲ. ಹಾಗಾಗಿ ನಾನೇನು ತಪ್ಪು ಮಾಡಿಲ್ಲ. ನನ್ನನ್ನು ಬಿಡುಗಡೆ ಮಾಡಲು ಕೋರುತ್ತೇನೆ. This is what he says. My lord, these 2 things, my lord, which I brought to my lord's notice is not part of the reply. ಅಲ್ಲಿ ಹೇಳ್ತಾರೆ ನನ್ನ ಪ್ರೊಪರೇಟ್ ನನಗೆ ಹೇಳಿದ್ದು ಆಗ ಫಿರ್ಯಾದುದಾರನ್ನು ಕಂಡು ನನ್ನ ಬಾಬ್ತು ಸಹಿ ಮಾಡಿದ ಮೇಲೆ ಹೇಳಿದ ಚೆಕ್ಗಳನ್ನು ವಾಪಸ್ಸು ಕೊಡುವಂತೆ ಕೇಳಿದ್ದೆ ಅಂತ ಹೇಳ್ತಾರೆ. ದಿಸ್ ಇಸ್ ಸಮಥಿಂಗ್ ದಟ್ ಹ್ಯಾಸ್ ನೆವರ್ ಬಿನ್ ಸೆಡ್ ಇನ್ ದಿ ರಿಪ್ಲೈ.
Yes.
For the first time, my lord, he only says I am not the proprietor, but he doesn't spell out as to who is the proprietor of the firm, the proprietary concern. That's all the examination in chief. My lord, 2 documents, my lord, as I brought to my lord's notice, have been marked in his evidence. Exhibit D1 is some invoice, my lord, that he produces, which he himself says it is nothing to do with the case on hand. And exhibit D2 is the certificate.
Yes, during
Cross-examination, my lord, 10/5/2016. ನಾನು ಸಿದ್ಧಾರ್ಥ್ ಎಂಟರ್ಪ್ರೈಸಸ್ ನ ಆಥರೈಸ್ ಸಿಗ್ನೇಟರಿ ಎಂದರೆ ಸರಿ. ನಮ್ಮ ಮತ್ತು ಫಿರ್ಯಾದುದಾರರ ನಡುವೆ ಕೆಲವು ವರ್ಷಗಳಿಂದ ವ್ಯವಹಾರ ಅಂದರೆ ಫರ್ನಿಚರ್ ಬಿಸ್ನೆಸ್ ವ್ಯವಹಾರ ಇದೆ ಎಂದರೆ ಸರಿ. ಏಪ್ರಿಲ್ 2012ರಲ್ಲಿ ನಾವು ಫಿರ್ಯಾದುದಾರರಲ್ಲಿ 10 ಲಕ್ಷ ಹಣ ಬೇಕೆಂದು ಕೇಳಿದ್ದೆ ಎಂದರೆ ಸುಳ್ಳು. ಫಿರ್ಯಾದುದಾರರು ನನಗೆ ಆಗ 10 ಲಕ್ಷ ರೂಪಾಯಿಗಳನ್ನು ದಿನಾಂಕ 16/4/2012ರಲ್ಲಿ ಕೈ ಸಾಲವಾಗಿ ಕೊಟ್ಟಿದ್ದರು ಎಂದರೆ ಸುಳ್ಳು. ನಿಪಿ 1A ಸಹಿ ನನ್ನ ಸಹಿ ಇರುತ್ತೆ ಎಂದರೆ ಸರಿ. ಸದರಿ ಸಹಿಯ ಕೆಳಗೆ ಸಿದ್ಧಾರ್ಥ್ ಎಂಟರ್ಪ್ರೈಸಸ್ ಮಾಲೀಕರು ಅಥವಾ ಅಧಿಕೃತ ಸಹಿದಾರರು ಎಂಬುದಾಗಿ ಬರೆದಿದೆ ಎಂದರೆ ಸರಿ. ಅದೇ ರೀತಿ ನಿಪಿ 2A ಸಹಿ ಸಹ ನನ್ನದೇ ಇದ್ದು ಆ ಸಹಿಯ ಕೆಳಗೆ ಸಿದ್ಧಾರ್ಥ್ ಎಂಟರ್ಪ್ರೈಸಸ್ ಮಾಲೀಕರು ಅಥವಾ ಅಧಿಕೃತ ಸಹಿದಾರರು ಎಂಬುದಾಗಿ ಬರೆದಿದೆ ಎಂದರೆ ಸರಿ. ನಿಪಿ 1 ಮತ್ತು ನಿಪಿ 2ರ ಚೆಕ್ಗಳು ನಿಪಿ 3 ಮತ್ತು ನಿಪಿ 4ರ ಅನುಸಾರ ಸಾಕಷ್ಟು ಹಣವಿಲ್ಲವೆಂಬ ಕಾರಣಕ್ಕೆ ಅಮಾನ್ಯಗೊಂಡಿವೆ ಎಂದು ಬದಲಿಗೆ ಸಹಿ ತಾಳೆ ಇಲ್ಲ ಎಂಬುದಾಗಿ ಏನು ಅಮಾನ್ಯಗೊಂಡಿಲ್ಲ ಎಂದರೆ ಸರಿ. ನಾನು ನನ್ನ ಮುಖ್ಯ ವಿಚಾರಣೆಯಲ್ಲಿ ನಿಪಿ 1 ಮತ್ತು 2ರ ಚೆಕ್ಕುಗಳನ್ನು ಫಿರ್ಯಾದುದಾರರು ಸಿದ್ಧಾರ್ಥ ಎಂಟರ್ಪ್ರೈಸಸ್ಗೆ ಫರ್ನಿಚರ್ ಸರಬರಾಜು ಮಾಡುವ ಸಂದರ್ಭದಲ್ಲಿ ನನ್ನಿಂದ ಸಹಿ ಮಾಡಿದ ಮತ್ತು ಮೊತ್ತ ಭರ್ತಿ ಮಾಡಿದ ಚೆಕ್ಕುಗಳನ್ನು ಪಡೆದುಕೊಂಡಿದ್ದಾರೆಂದು ಹೇಳಿದ್ದೇನೆ ಎಂದರೆ ಸರಿ. ನಿಡಿ 1ಕ್ಕೂ ಈ ಪ್ರಕರಣಕ್ಕೂ ಯಾವುದೇ ಸಂಬಂಧ ಇಲ್ಲ ಎಂದರೆ ಸರಿ. ನಿಡಿ 1ರ ಬಿಲ್ ಹಣವನ್ನು ನಾವು ಭರ್ತಿ ಮಾಡಿದ್ದರೂ ಕೇವಲ ನ್ಯಾಯಾಲಯವನ್ನು ತಪ್ಪುದಾರಿಗೆ ಎಳೆಯುವ ಉದ್ದೇಶದಿಂದ ಆ ನಿಡಿ 1ರ ದಾಖಲೆಗಳನ್ನು ನ್ಯಾಯಾಲಯಕ್ಕೆ ಹಾಜರುಪಡಿಸಿದ್ದೇನೆಂದರೆ ಸರಿಯಲ್ಲ. ನಿಡಿ 1ರ ಬಿಲ್ನಲ್ಲಿ ಬರೆದಿರುವ ಚೆಕ್ ನಂಬರ್ಗೂ ಈ ಪ್ರಕರಣ ನಿಪಿ 1ರ ಚೆಕ್ಗೂ ಯಾವುದೇ ಸಂಬಂಧ ಇಲ್ಲ ಎಂದರೆ ಸರಿ. ನಾನು ನನ್ನ ಮುಖ್ಯ ವಿಚಾರಣೆಯಲ್ಲಿ ನಿಪಿ 1 ಮತ್ತು ನಿಪಿ 2ರ ಚೆಕ್ಕುಗಳ ನಗದೀಕರಣವಾಗದೆ ವಾಪಸ್ಸು ಬಂದ ಬಗ್ಗೆ ಹೇಳಿದ್ದು ಆಗ ನಾನು ಫಿರ್ಯಾದುದಾರರನ್ನು ಕಂಡು ನನ್ನ ಬಾಬ್ತು ಸಹಿ ಮಾಡಿದ ಚೆಕ್ಗಳನ್ನು ವಾಪಸ್ ಕೊಡುವಂತೆ ಕೇಳಿದಾಗ ಫಿರ್ಯಾದುದಾರರು ಆ ಚೆಕ್ಗಳನ್ನು ನಮ್ಮ ಸಿದ್ಧಾರ್ಥ ಎಂಟರ್ಪ್ರೈಸಸ್ ಮಾಲೀಕರಿಗೆ ಕೊಡುವುದಾಗಿ ಹೇಳಿದ್ದರು. ಆ ಚೆಕ್ ಅನ್ನು ಫಿರ್ಯಾದುದಾರರು ನಮ್ಮ ಸಿದ್ಧಾರ್ಥ ಎಂಟರ್ಪ್ರೈಸಸ್ ಮಾಲೀಕರಿಗೆ ಕೊಟ್ಟರೋ ಇಲ್ಲವೋ ಗೊತ್ತಿಲ್ಲ. ನಾನೇನು ಚೆಕ್ಗಳನ್ನು ಫಿರ್ಯಾದುದಾರರು ವಾಪಸ್ಸು ಕೊಟ್ಟರೋ ಇಲ್ಲವೋ ಎಂಬುದರ ಬಗ್ಗೆ ನಮ್ಮ ಮಾಲೀಕರಿಗೆ ಕೇಳಿಲ್ಲ. ನಾನೇನು ಚೆಕ್ಗಳನ್ನು ವಾಪಸ್ಸು ಕೊಡ ಹಿನ್ನೆಲೆಯಲ್ಲಿ ಫಿರ್ಯಾದುದಾರರಿಗೆ ಯಾವುದೇ ನೋಟಿಸ್ ಅನ್ನು ಕೊಟ್ಟಿಲ್ಲ ಅಥವಾ ಬ್ಯಾಂಕ್ನವರಿಗೆ ಸ್ಟಾಪ್ ಪೇಮೆಂಟ್ ಸೂಚನೆ ಕೊಟ್ಟಿಲ್ಲ. ಕಾರಣ ಅದು ನನ್ನ ಸ್ವತಂತ್ರ ಖಾತೆ ಏನೂ ಅಲ್ಲ. ಸದರಿ ಸ್ವತ್ತುಗಳ ಬಾಬ್ತು ನಮ್ಮ ಪ್ರೊಪರೇಟರ್ ಕಡೆಯಿಂದ ಸ್ಟಾಪ್ ಪೇಮೆಂಟ್ ಸೂಚನೆ ಕೊಡಿಸಿಲ್ಲ. ಕಾರಣ ಅವರೇ ಆ ಬಗ್ಗೆ ನಿರ್ಧಾರ ತೆಗೆದುಕೊಳ್ಳಲು ಅರ್ಹರಾಗಿರುತ್ತಾರೆ. ನಾನು ನನ್ನ ಮುಖ್ಯ ವಿಚಾರಣೆಯಲ್ಲಿ ನಿಪಿ 1 ಮತ್ತು ನಿಪಿ 2ರ ಚೆಕ್ಕುಗಳು ಅಮಾನ್ಯಗೊಂಡ ಹಿನ್ನೆಲೆಯಲ್ಲಿ ಫಿರ್ಯಾದುದಾರರು ನಮಗೆ ನೀಡಿದ ನೋಟಿಸ್ಗೆ ನಾವು ನಿಪಿ 9ರಂತೆ ಉತ್ತರಿಸಿದ್ದೇವೆಂದು ಹೇಳಿದ್ದು ಸದರಿ ಉತ್ತರದ ನೋಟಿಸ್ನಲ್ಲಿ ನಾನು ನಿಪಿ 1 ಮತ್ತು ನಿಪಿ 2ರ ಚೆಕ್ಕುಗಳನ್ನು ಫಿರ್ಯಾದುದಾರರ ಬಳಿ ವಾಪಸ್ಸು ಕೇಳಿದ ವಿಚಾರವನ್ನು ಹೇಳಿಲ್ಲ. ನಾನು ಫಿರ್ಯಾದುದಾರರಿಗೆ ನಿಪಿ 1 ಮತ್ತು ನಿಪಿ 2ರ ಚೆಕ್ಗಳನ್ನು 10 ಲಕ್ಷ ರೂಪಾಯಿಗಳಿಗೆ ಸಾಲ ತೀರುವಳಿಗಾಗಿ ಕೊಟ್ಟಿದ್ದರೂ ಸಹ ಜವಾಬ್ದಾರಿಯಿಂದ ನೊಣಚಿಕೊಳ್ಳುವ ಸಲುವಾಗಿ ಸುಳ್ಳು ನಿಲುವನ್ನು ತೆಗೆದುಕೊಂಡು ಸುಳ್ಳು ಸಾಕ್ಷ್ಯ ನುಡಿಯುತ್ತಿದ್ದೇನೆಂದರೆ ಸರಿಯಲ್ಲ.
Yes.
And hence, my lord, at no point of time ever a defense was ever taken.
What are the reasons given by? One is the proprietor of the concern is not a made party.
It's not made up.
Is the only reason?
That's the only reason. From para 17, my lord, that's my lord. Page 17, para 17. Till then, my lord, all the formalities being, my lord, fulfilled regarding the issuance of the notice, etc., is discussed. From para 17, my lord, the discussion would begin. No doubt, my lord, this is how it begins. No doubt, the accused failed to prove the fact of the circumstances in which the disputed exhibit P1 and P2 checks went to the possession of the complainant. By proving his defense, either the defense of the accused that since the accused was very close to the complainant had misused the check of the accused, concern, etc. And another defense that the complainant had allegedly obtained two signed blank checks of the accused concern, except filled up with amount column only as security at the time of supplying furniture to the accused enterprises. But in order to bring home the guilt of the accused for the offense punishable under Section 138 of Negotiable Instrument Act, the complainant must necessarily prove the fact of existence of debt or liability in between the complainant and the accused. Further, Section 138 of Negotiable Instrument Act is clear that the person liable to answer this penal provision is only the person who had drawn the check, which could be seen from the opening words, where any check drawn by a person on an account maintained by him, and thereby indicating the person liable to be dealt with under Section 138 of Negotiable Instrument Act, or the person answerable under Section 138 of the Act, must be the person who had drawn the check and who is having account in which the check was drawn and not others. In this case on hand, as it is admitted by PW1, checks, that is Exhibit P1 and P2 checks, were drawn from the account of proprietary concern of Siddhartha Enterprises. That means to say that the account holder is measures Siddhartha Enterprises, and Exhibit P1 and P2 checks were pertaining to the bank account of Siddhartha Enterprises. Hence, the accused is only a mandate holder who was competent and authorized to sign on behalf of account holder or on behalf of drawer. Therefore, the mandate holder certainly will not come within the meaning of a person, check drawn by a person or an account maintained by him. This being the case, the complainant ought to have been filed this case against the owner or proprietor of Measures Siddhartha Enterprises who maintained the account, who had drawn the check, though it was signed by mandate holder, that is the authorized signatory Srinath Hegde. Because the role of the mandate holder or authorized signatory is limited in the sense obeying the mandate of or any of the member in this was alone, the accused has signed Exhibit P1 and P2 checks as authorized signatory or mandate holder. Hence, the accused cannot be held responsible for the offense punishable under Section 138 of the Negotiable Instrument Act. Then, my lord, 22, 23, and 24, my lord, the discussions on the rulings are made. And eventually, my lord, it is said that since the proprietor is not made a party.
ಏನಾಗಿದೆ ಎಡ್ಯುಕೇಟ್ ಇದಾರಲ್ಲ ತಗೊಳ್ಳಿ ಬನ್ನಿ. The appellant being the complainant in SCC number 32436 of 2014 on the file of the Leonard 13 Additional Chief Metropolitan Magistrate Bengaluru is in the judgment dated 21/6/2016, acquitting the respondent accused for the offense punishable under Section 138 of an Act. The facts of the case are that parties are referred to other non-party. The complainant has filed the private complaint in PCR 17428 of 2014 against the respondent accused, alleging commission of offense punishable under Section 138 of an Act. It is contended by the complainant that he is the proprietor of a business concern by name Mercury Enterprises. He was into manufacturing and trading of furnitures. The accused is his close associate. And he approached the complainant during April 2012, stating that his proprietary concern, that is Siddhartha Enterprises, is facing financial difficulties and therefore requested for hand loan. Accordingly, the complainant lent an amount of Rs 10 lakh on 15/4/2012 in cash. The accused has issued the on-demand promissory notes in favor of the complainant, which was attested by one Shri A.R. Guru Prakash as a witness. Thus, the accused has promised to repay the hand loan of rupees 10 lakh with interest at 3% per annum. Next one. The complainant contended that towards discharge of the legally enforceable debt, the accused issued 2 checks as per Exhibit P1 and 2 for rupees 5 lakh each, dated 11/9/2014. When the checks were presented for encashment, both the checks were dishonored as there was insufficient fund furnished. A legal notice was issued to the accused. On receipt of the same, the accused had issued the reply as per Exhibit P9, but had not repaid the check amount. Thereby, he has committed the offence punishable under Section 138 of NI Act. Accordingly, he requested the trial court to take cognizance of the offence and to initiate legal action. The trial court took cognizance of the offence and registered CC number 32436 of 2014 against the accused for the offence under Section 138 of NI Act. The accused had appeared before the trial court and pleaded not guilty. The complainant examined himself as PW1 and got marked Exhibit P1 to 10 in support of his contention. The accused has denied all the incriminating materials available on record and examined himself as DW1. He got marked Exhibit D1 and 2 in support of his defense. The trial court, after taking into consideration all these materials on record, came to the conclusion that the complainant is not successful in proving the guilt of the accused beyond reasonable doubt. Accordingly, the accused was acquitted. Being aggrieved by the same, the complainant is before this court. So and so. The counsel for the complainant contended that it is the specific contention of the complainant.
Kindly pass on the colleague.
So you have to address the argument. Ask him to come. Ask him to come. Ask him to come. Contention of the complainant that he had lent an amount of rupees 10 lakh on 16/4/2012 and acknowledging the same, the accused had issued the on-demand promissory note in the presence of a witness. Towards discharge of this the loan, hand loan, the accused had issued the checks as per Exhibit P1 and 2 dated 11/9/2014 for rupees 5 lakhs each. Both the checks were dishonored when presented for encashment with an endorsement that the funds insufficient in the account of the accused. Legal notice was issued calling upon the accused to pay the check amount. Instead of paying the check amount, the accused had issued an untenable reply as per Exhibit P9. Even though the reply was issued, no specific stand was taken with regard to the checks Exhibit P1 and 2. Next one. Counsel further submitted that during cross-examination of PW1, the accused admitted issuance of the checks Exhibit P1 and 2 with his signature. Only defense appears to have been raised during cross-examination of PW1 is that the complainant had misused the checks Exhibit P1 and 2. But there is no specific stand as to why the accused had issued those checks to the complainant. Next part. The counsel further submitted that the accused has examined himself as DW1. He took a defense that Exhibit P1 and 2 were not given by the accused to the take a defense. Counsel further submitted that
No more law.
file a memo. Death certificate you have to produce. DW1. During his evidence, he specifically admitted issuance of check as per Exhibit P1 and 2. a new defense was taken that when the complainant supplied furnitures, he had issued blank checks as per Exhibit P1 and 2 with his signature. DW1 specifically states that, yes, file a memo. When you make a submission, you should be certain about that. States that he is the authorized signatory for the proprietary concern Siddharth Enterprises. Who is the proprietor of Mr. Siddharth Enterprises. Witness also admits that Exhibit P1 is not concerned to be dealing with the complainant. During cross-examination, he specifically states that he never demanded back the checks from the complainant. No notice was issued following upon the complainant to return the checks. Witness also admits that the defense taken in his evidence were not stated in the reply notice. All these facts and circumstances discloses that the accused categorically admitted issuance of the checks Exhibit P1 and 2 with his signatures as the authorized signatory to the proprietary concern measures Siddharth Enterprise. Under such circumstances, the presumption under Section 139 of NA Act would arise. The burden shifts on the accused to rebut the presumption. From the evidence that is led by the accused, he is not successful in probabilizing his defense. Even though the accused had taken the defense that he had issued the blank checks in favor of the complainant, that will not absolve him from his liability. When even according to the accused, he is the authorized signatory to measures Siddharth Enterprises, which is a proprietary concern, he is liable as a drawer of the check. The trial court has committed an error in holding that the complainant has not proved the existence of legally enforceable debt, as it is a matter of presumption under Section 139 of NA Act. Even though the trial court held that the accused has not proved his defense regarding misuser of the checks by the complainant, committed an error holding that the proprietor of the proprietary concern is not made as party, and only the authorized signatory is arrayed as an accused, and proceeded to dismiss the complaint, acquitting the accused. The finding recorded by the trial court is perverse, illegal, and the same is liable to be set aside. Accordingly, he prays for allowing the appeal in the interest of justice. Dead ante.
No, he's not there. He said to me that Shashikala is no more. Now, Srinath Hegde is very much alive, is what he told me now.
Just verify with your client. Just get clarification.
He told me that Srinath Hegde is there when I called in the morning.
Get clarification from your client.
My client also told me in the morning that Srinath Hegde is very much there.
Yes. Pass over.
Please.
Pass over.
Please.
Passed over matter, serial number 2, Girish DS, KP Jaisimha.
Serial number?
Serial number 2. Serial number 2.
Yes, who is for the appellant?
Girish DS. List 2, serial number 2.
bit of it, last bit of,
Put it.
patient, my lordship.
Hmm.
Admitted in hospital, good hospital, judgment. I'm not happy. with it.
Are you ready to address the argument?
Yes, my lordship, I'm ready.
Please address the argument.
From the board, in the official custody.
Yes, I'll consider that. Please address the argument. Yes, 138.
The 138 matter, my lordship.
Yes.
Check amount is 3,50,000. My lordship.
Hmm.
Disregard my lordship. The DW1 is examined.
Now, what is the contention of the complainant?
And contention is already paid, my lordship.
Hmm?
Is received 1 lakh. So.
No, I am asking you, what is the contention of the complainant?
Complaint is, he given the check, he has to pay the 3,50,000.
Sir, what is the contention taken by the complainant in the complaint?
After the 3,50,000, the respondent has to pay. This is the contention.
Why?
Due to issue check.
Why he has issued the check?
So he should check, he give the hand loan.
ಅದನ್ನಲ್ವಾ ಮೊದಲಿಗೆ ಹೇಳ್ಬೇಕಾಗಿದ್ದು?
ಹೌದು.
ಹಾ.
Hand loan ಕೊಟ್ಟಿದ್ದಕ್ಕೆ.
ಯಾವಾಗ?
10/2/2013.
10/2/2013. How much?
3,50,000.
Yes, then
the respondent contention is.
Respondent contention ಬೇಡ. First ಗೆ complainant contention ತಮ್ಮ ಹತ್ರ ಕೇಳ್ತಾ ಇದ್ದೀನಿ.
In 2011, the respondent is requested the hand loan of rupees 3,50,000.
Hmm.
And she given the 3,50,000 to the respondent.
When?
That's 13/8/2011.
13/8.
13/8/2011. Accused is trying to pay the repayment of the loan.
Where it is stated 13/8.
13/8 is
You are not ready with the matter.
examination.
Till you are not ready to address the argument, you do not know the facts of the case.
Ready.
You don't know the facts. Where it is stated on 13/8/2011, he had lent the land.
Examination of the PW1.
Where the contention of the complainant, you will find contention of the complainant.
Contention of the complaint is should be the hand loan of rupees 3,50,000.
Where we find that?
That is in chief examination of the.
Before chief examination.
Before chief examination, that is complaint to PCR. That is page number 2 of paragraph number 4.
Whether it is contention that on 13/8/2011, I have lent the amount.
In 2000 wrong certificate plan issued in branch. That is 13/8/2011. The complaint with the intention yet the accused and actually repayment of the loan amount of paid is 3,50,000 and then.
I will reject your application. Since you are not ready, I will not entertain that application.
Tomorrow I am ready, my lordship. Can you consider my?
No. Unless you address your argument, I will not consider. You do not have that seriousness. Your client is inside, still you are not serious about this. Still you do not know the facts of the case. Basic facts you do not know.
I'm hospitalized the last.
Maybe, sir, I am not concerned about that.
Tomorrow, my lordship.
Tomorrow, raise for time.
My lord, consider my lord.
No, nothing.
Can you pass over, my lord? I'm ready to argue. Can you pass over? Can you pass
Very
over?
casually you are appearing before the court. You are under the impression the court will hear you. Without hearing you, allow the application. Don't be under such impression. Next,
Can you pass over?
next.
Ready, sir.
Ready in the E-riti alla, sir.
In the ready, sir, after lunch, I'm ready.
Next.
Serial number 3, government advocate,
Can you pass over?
PM Kushalappa.
Can
It
you
is
pass over?
passed over, sir. Next matter is called.
Please.
3, government advocate, PM Kushalappa.
Respondent, number 1.
You are for?
And for respond number 1, man. There are 2 accused and 2 respondents.
Absconding ನಿಮ್ಮ
ಇಲ್ಲ ನಮ್ಮವರಲ್ಲ. 2 is abscond.
2 is absconding. You are for 1 na?
1.
Yes, go ahead. Calcutta record ಬಂದಿಲ್ಲ. ತಗೊಳ್ಳಿ. The letter received from the trial court discloses that respondent number 2 is absconding and he is said to be in abroad. LOC is also issued against him. Learned SCP and learned counsel for respondent number 1 are present. Both the learned counsel undertake to address their arguments on merits on the next date of hearing. I'll call for trial court records and list for admission. Yes, please address their argument. Next.
14, Bhartiyam.
This is for the appellant, my lord. My lord, there is a delay of 112 days, my lord. I filed a medical certificate of the appellant's mother along with this IA, my lord. Morning, I apologize. My colleague was here. I apologize for that, my lord. I'll make my submissions.
Third learned counsel for the appellant, May 1 and 2 of 2020. So, satisfied with the grounds made out in the affidavit accompanying the application. Delay of 112 days in preferring the appeal is condoned, leave is granted. All for trial court records, list for admission. IAs are allowed, list for admission.
Please. Serial number 54, Prasanna Kumar, Sriranga, HN Vasudevan, government advocate.
I'm filing objections, my lord.
Copy.
In which matter?
Common objection, my lord. Common objection.
In all the 8 matters.
All the common objection, my lord. I've served the copy on the petitioners, my lord.
CGP filed statement of objections on behalf of respondent number 1. Common statement of objections. Yes,
Lords, I may be given 2 weeks' time. I have to go through it and I'll also place few other documents on record.
2 weeks time. ಒಂದ್ಸಲ ಎಲ್ಲ ಕೇಳಾದ್ಮೇಲೆ 2 weeks, 2 months.
Illa, a week's time at least. I'll have to, because a lot has been said on factual aspects. I'll just have to traverse that comprehensively.
Counsel for the petitioner prays for time to address his reply argument. This down. Anything to be submitted?
My lord, we'll adopt the
ಅಲ್ಲಿ HCGP common judgment, statement of objection. And he submits that he adopts the arguments addressed on behalf of respondent number two na.
One.
No, you are representing
My lord, all the respondent number two.
two.
Or one line. De facto.
I appear only in 6885.
6885.
It is 54.3, my lords.
In other matters, who is representing?
Lords, other offices are there, my lords.
There must be somebody on record. Reply. No. Please address the argument on the next date of hearing. No.
Definitely.
Hmm. 11th December.
Grateful. May be taken up at 2:30 minutes.
2:30 ಬೇಡ sir. ನೋಡೋಣಂತೆ. ನೋಡೋಣ. On that day, you make a submission.
Great.
Yes. You please inform the other counsel for the petitioners. If they have anything to say, let them say on the same day.
Please.
Serial number 55, HK Simegowda, KV Shiva Reddy.
ಕೊಡಿ. But ಮೊದಲೇ ಫೈನಲ್ ಅಂತ ಆಗಿತ್ತಲ್ಲ. Okay, not final. Counsel for the appellant is absent, no representation. Appeal is of the year 2013. I do not find any reason to adjourn the matter. However, to offer final opportunity, list on.
Serial number 57, Surendra Kumar L.
LCR.
ಬಂದಿಲ್ಲ. Last time finally ಮಾಡೋ ಮೊದಲು ಮಾಡ್ಬೇಕಲ್ವಾ? Yes, tell me what is the facts? I am having the judgment, how it is wrong?
Short accommodations. For 2 days.
Dismiss ಮಾಡ್ತೀನಿ. Nothing.
Kindly pass. That's 2 days time for I will.
It is posted finally. Please get ready and address your arguments.
Serial number 58, Sham Samad Patan, Krishnamurthy.
ಅದೇನಾಗಿದೆ? Finally. ಕೊಡಿ. ಇನ್ಯಾವುದಿದೆ? ಇನ್ಯಾವುದು ಇಲ್ಲಲ್ಲ? ಆಯ್ತಲ್ಲ? ಅದು ಬಿಡಿ, ಬೇರೆ ಯಾವ್ದು ಇಲ್ಲ ಅಂತ. ಯಾವುದು? ಆಮೇಲೆ ಇದನ್ನು ಕರೀರಿ ವಾಪಸ್.
Serial number 60, Hariprasad MB, these two.
Complaint appeal, my lord.
Serial number 60.
60.
60.
Against the judgment of acquittal in CC number 1458 of 2020, dated 24/4/2024. The accused number 1 happened to be the mother of the accused number 2, my lord.
No, offense under 138.
138, my lord.
Why
Two
two accused?
My lord.
Why there are two accused?
Two accused, my lord. Accused number 1 is actually the mother who has issued the check. But by way of inadvertence, accused number 2, the son is also made as accused. And also the trial court took the cognizance against both the accused persons, my lord.
How can it be?
That was same also, the argument was canvassed, and also a reference is made by the trial court that my submission was taken that since accused number 2 has got nothing to do with the transaction of 138, he may be acquitted. That was the submission made before trial court.
But cognizance was taken
Hmm.
initially.
Right, then,
Now
what
the
is your
case,
contention?
please, my lord.
What is your contention?
Before taking my contention, my lord, what the trial court has.
I am not
Please, my lord.
interested, sir.
Please, please.
Let us go systematically.
Please, my lord.
First, let me understand what is your contention.
My contention is that, my lord, I have advanced a sum of rupees 6,50,000 to accused number 1.
6 lakh,
50,000, my lord. To accused number 1
when,
in November 2016, my lord.
why?
But for two things, my lord. One is for the conduct of daughter of the first accused, for performing the marriage of the first accused daughter. Second one is that accused number 1 was suffering from some abnormalities with regard to her stomach. So for that operation also, rupees 6,50,000 in total was given, my lord, which is not disputed.
Then,
Then, my lord, they issued a check. 3 checks were issued, my lord.
Hmm.
In order to repay this check amount, 3 checks were issued.
those are the subject matter of this present.
Two are the subject matter of this judgment, my lord. One is not the subject matter because the one which was issued for rupees 2,50,000 was honored.
First check is for,
First check was for rupees 2,50,000. Check number 1124, my lord.
dated,
Dated 4/1/2020, my lord.
4/1/20.
2020.
That was honored.
That was honored.
Then the second check,
The second check was, my lord, 1121 dated 4/10/2019, previous to the issuance of that check.
4/1.
4/1/2000, 4/10/2019, my lord. For rupees 2 lakhs.
Ah,
And one more check was issued, 1123.
Hmm.
Dated 4/4/2020.
Hmm.
For rupees 2 lakhs, my lord.
Hmm.
Now, 2 cases came to be filed under section 138.
Right, what happened to the checks?
My lord. Check number 1121 and 1123,
Hmm.
which is the subject matter of the present case, got dishonored, my lord, as funds insufficient.
Then,
The check which was issued 1124 for rupees 2,50,000 was honored.
yes,
Now, my lord, dishonor was taken place on 15/4/2020 for insufficient fund. Notice got issued on 26/6/2020,
Hmm.
which is a mandatory requirement of 138B, and reply was also given.
yes. What is the defense taken?
Defense taken by them, my lord, is that one is with regard to acquittance, that the complainant is a stranger. At one stage, they take a stand that he is a stranger.
Hmm.
Subsequently, they admit the fact
Hmm.
that he is acquainted.
Hmm.
Second one is, my lord, the checks were stolen.
Stolen by?
Stolen by the complainant.
Yes.
And the third defense that is taken by the accused number 1 is that she disputes the signature, though the check was dishonored for the reasons of funds insufficient.
ಇದು admission ಇದೆಯಲ್ಲ, notice ಆಗಿಲ್ಲ. Why the trial court acquitted?
Well, a trial court acquitted even after making the findings that probable defense were not taken and also was not successfully rebutted, only on the contention that with regard to the income, my lord, though the complainant was cross-examined length and he has deposed certain documents stating that he happened to be the auditor in the state government and draws a salary of 90,000, my lord.
Where is the reasoning given by the trial court?
Yes, my lord. The reasoning starts, my lord. It says that analysis at page 43, para 30, my lord.
You need not have to read the entire thing, sir.
Please,
You
madam.
can say, what is the reasoning given by the trial?
The reason is that, my lord, with regard to the acquittal, is at page 58, para 64. Which runs 7 lines, madam. May I read out that portion, my lord? Para 64, my lord.
Hmm.
It is a settled principle of law that when the accused rebut the presumption of probable defense. So probable defense taken was with regard to two things, which my lords could see at page 43. According to the trial court, learned trial court judge, my lord, probable defense that were taken at page 43, two probable defense were taken. According to trial court, that has been proved. One is that the first defense that is taken, my lord, 43, my lord, for a moment, my lord, may I? 43, my lord. What is actually the defense according to the trial court, my lord?
Why you want to read the judgment, sir? You can say
Please,
this is
madam.
the reason given by the trial.
The first probable defense according to the trial court is that the check was stolen, which is not proved by any cogent material. No complaint was there.
Why the trial court accepted that?
Accepted without any reasons. That's for that reason I am before this, my lords, my lord.
Yes, then
The
second.
second defense is that with regard to the income proof, whether he was capable, the complaint was capable of lending 6,50,000 was the second defense that was raised. Though there was a material to substantial fact that he is working as a state auditor who is drawing a salary of net salary of more than 90,000.
Counsel for the appellant on admission, satisfied with the grounds made out in the memorandum of appeal. Appeal is admitted, call for trial court records, issue notice to respondent. Appeal is admitted, issue notice.
Great, for one.
Passed over matter, list 1, serial number 19.
ಏನಾಗಿದೆ? ಕೊಟ್ಟಿಲ್ಲ ತಾನೆ? ಮತ್ತೆ ಮಧ್ಯಾಹ್ನ ಕರೀರಿ ಅದನ್ನು. ಕೊಟ್ಟಿದ್ರೆ ಮಾತ್ರ ಕರೀರಿ.
Serial number 32, Jagdish ST.
Counsel for the appellant submits that needful is done, office to verify if PF is paid. Issue notice to respondent along with the application.
34, Manjunath Bia, needful is done.
The same. Then. Right.
I appear for respondent in serial number 56, which has been passed over when my learned friend has. Yes, please. Sir, respondent's wife has passed away on 3/11/2024.
We are not concerned with his wife, sir.
One humble submission, please. My only request is, my lord, when I called yesterday, my lord, she didn't pick the call. Son had picked the call, my lord, she informed that he was not picking well. Therefore, I didn't have instruction, my lord. If you lordship may kindly.
What instructions you want, sir?
My lord, my only.
This is the appeal of 2016.
No, my lord.
While accepting the wakalat, you don't take any instructions?
My lord, what has happened is, my lord, the reason is this, my lord. His son who had visited the office, my lord, he took the file for the purpose of his reference. Therefore, my lord, kindly have tomorrow, my lord. I'm not seeking much time. I wouldn't have, my lord, please.
Sir, I am not here to accept all those contentions or the submissions.
Kindly have tomorrow, my
I
lord.
know the veracity of such submissions. Even you know, I know, everybody know.
No doubt, my lord.
Then-
In fact, I have sent my office boy, my lord, to bring the file from him. Or else, my lord, I wouldn't have made this submission. And he was not keeping well, my lord.
Counsel for the appellant. Then counsel for the respondent.
Tomorrow, my lord.
Takes the time. The appeal is of the year 2016. I do not find any reason to adjourn the matter. However, to afford final opportunity listed tomorrow.
Please.
No further date will
No,
be
please.
given.
I won't seek any attention.
If you remain absent, I will proceed, since I have already heard the other side.
I do want.
Yes. I've heard further argument.
Please, great.
Don't seek for Passover and
No.
all. Please proceed. Yes. next.
That
57.
Serial number 57, Surendra Kumar.
ಅದೇನು ಟ್ರಯಲ್ ಕೋರ್ಟ್ ರೆಕಾರ್ಡ್ ಬಂದಿಲ್ವಾ? ಕೊಡಿ, ಆರ್ಡರ್ ಶೀಟ್ ಕೊಡಿ. Counsel for the appellant is absent, no representation, even when the matter is passed over twice and called again at 12:25 PM. The order sheet dated 21/8/2024 reads as under. In spite of that, there is no representation. It is noticed that the trial court records is not yet called. Hence call for trial court records. And list immediately after receipt of TCR. Next.
ಸ್ವಲ್ಪ ಲೇಟ್ ಆಗೋಯ್ತು ಅವ್ರಲ್ಲಿ ಆಫೀಸ್ ನಲ್ಲಿ ಕೇಳ್ಕೊಂಡು ಬರ್ಲಿಕ್ಕೆ ಲೇಟ್
ಯಾವ್ದು? ಹಾ?
ಮಾರ್ನಿಂಗ್ ಯಾವ ಕೋರ್ಟಿಗೆ ಹೋಗ್ಬೇಕು ಅಂದ್ಬಿಟ್ಟು ರಿಗಾರ್ಡಿಂಗ್ ದಟ್ ನಾಳೆಗೆ ಬೇಕು ಮೇಡಮ್ ಈ ಪೇನ್ ಇದೆ ನನಗೆ ಸೆಕೆಂಡ್ ಟೈಮ್ ಐ ಆಮ್ ಅಪಿಯರಿಂಗ್
ನೋಡೋಣ ಅದು ಯಾವಾಗ ಇವ್ರ ಪಾರ್ಟಿನ?
Yes, party in person, my lordship. In this case, I am the complainant and the petitioner.
Monday, ma'am.
It is 482, my lordship,
Yeah,
23.
ಮಂಡೇ ನಾಳೆ ಕ್ರಿಮಿನಲ್ ಪಿಟಿಷನ್ ಬರಲ್ಲಮ್ಮ, ನಾಳೆ ಅಪೀಲ್ ಡೇ. ಸೊ ಮಂಡೇ ತಗೊಳ್ಳಿ. ಎಸ್, ಮಂಡೇ ಬನ್ನಿ. ಇನ್ನೂ 1 hour ಇದೆಯಲ್ಲ ಟೈಮ್. ಅಬ್ಸೆಂಟ್ ಇರುತ್ತೆ ಕೊಡ್ರಿ. 58 23.
Serial number 58, Sham Samad Patan.
ಕೊಡಿ, ಫೈಲ್ ಕೊಡಿ. ಅದನ್ನೇ ಹೇಳ್ತಾ ಇದ್ದೀನಿ.
Krishnamurthy.
ಕೊಡಿ ಟ್ರಯಲ್ ಕೋರ್ಟ್ ರೆಕಾರ್ಡ್ಸ್ ಕೊಡಿ. ಡಿಕ್ಟೇಷನ್ ಸ್ಟಾರ್ಟ್ ಮಾಡ್ತಾರೆ, ಬರ್ತಾರೆ. ನಿಮಿಷ ಕೂತ್ಕೊಳ್ಳಿ, ಚೂರು ನೋಡಿ ಆಮೇಲೆ ಸ್ಟಾರ್ಟ್ ಮಾಡ್ತೀನಿ. Hold, fine. The appellant being the complainant in the CC 32086 of 2006 on the file of so-and-so is impugning the judgment dated 22nd August 2013, acquitting the respondent accused for the offence punishable under section 138 of Indian. Brief facts of the case are there. Parties are referred to. The complainant filed private complaint, PCR number 6932 of 2006, against accused number 1 to 5, alleging commission of the offence punishable under section 138 of an act. It is contended that accused number 1 is a private limited company. Accused number 2 is the chairman and managing director. 3 to 5 are the directors, and they are actively participate in the business of accused number 1. Next part, it is contended that the accused conducted the business show under the name and style as Bangalore Consumer Expo 2005. For 25 days. They availed the services of the complainant for providing men and materials, exhibition space, and for infrastructure and decoration. Accused agreed to pay rupees 25 lakhs to the complainant, and towards part payment they have issued futures. Out of the same, check bearing number 597331 dated 4/5/2005 was for rupees 5 lakh, and check bearing number 597339 dated 21/5/2005 is for rupees 6 lakh. And both these checks were presented for encashment. The same were dishonored as there was insufficient funds. The complainant issued the legal notice, calling upon the accused to repay the check amount. In spite of the receipt of the legal notice, they have not repaid the check amount. Accused number 4 sent the reply but not repaid the amount, and thereby all the accused have committed the offence punishable under section 6. And they send the reply denying the liability, thereby committed the offence punishable. Accordingly, prayed the trial court to take cognizance of the offence and to initiate legal action. Trial court took cognizance of the offence and initiated legal action. The accused appeared before the trial court and pleaded not guilty for the offence under section 138 of an act. Complainant examined PW1 and got marked exhibit P1 to 11 in support of his contention. The accused denied all the incriminating materials available on record and examined DWs 1 to 4 in support of 1 to 4 and got marked exhibit D1 to 58 in support of their defense. The trial court, after taking into consideration all these materials on record, came to the conclusion that the complainant is not successful in proving the guilt of the accused beyond reasonable doubt. Accordingly, the accused were acquitted. Being aggrieved by the same, the complainant is before this court. When counsel to the appellant and respondent are absent no representation, in spite of giving sufficient opportunity, they have not addressed their arguments. Peruse the materials, including the trial court records, found for consideration and answer to the point is in the negative for the following reason. It is the contention of the complainant that he had provided services to the accused. Accused number one is, which is a company represented by 2 to 5 who are the directors. And the accused were liable to pay rupees 25 lakhs. Towards repayment of the same, accused had issued checks, 2 checks as per exhibit P 1 and 2 for rupees 5 lakh and 6 lakh each on 4/5/2005 and 21/5/2005. But both the checks were dishonored on presentation as there was insufficient fund in the account of the accused. In spite of service of notice, the accused have not repaid the check amount. Accused number 4 has issued a reply taking untenable contentions, denying his liability. Accused number 2 and 5 have issued the notice, denying their responsibility to pay any amount. And thereby all the accused have committed the offense punishable under section 138 of NA. Hence the agreement between the parties. The accused was examined indicators 1 to 4, denying their liability to pay any amount. It is the contention of accused number 2 and 5 that they are not concerned with the accused number 1 company, and it was only accused number 4 who was dealing with the matter. According to accused number 4, even though they admits entering into the agreement and engaging the services of the complainant, contends that the entire amount is already paid. The 9 to 59, which was paid to Jamil and Ramesh. It is pertinent to note that exhibit to D 9 to 59 are similar vouchers of different dates for having paid specific amount and the recipient of the amount is Zamir and Parmesh. For and on behalf of Hussain Furnitures. That is the complement herein. It is pertinent to know that PW1 admitted exhibitor for voucher dated 7/5/2005 for having acknowledging the receipt of 25,000 for and on behalf of Hussain Brothers. That is the complainant. Exhibit D9 and 9 to 59 are similar vouchers when compared with exhibit D2, which is an admitted document. The complainant contended that Zamir and Parmesh referred to in the vouchers exhibit D9 to 59 were not his employees. During cross-examination, PW1 categorically admits that he maintains a master role and he has no objection to produce the same before the court. But no such document is produced in support of his defense that the recipient of the amount under exhibit D9 to 59 were not his employees and were not on master roll. There is absolutely no reason for the complainant to produce the said master roll. When a specific defense is taken by the accused by producing exhibit D9 to 59 and contended that the amount is already paid under the vouchers. When the disputed vouchers are compared with exhibit D2 and admitted voucher, I am of the opinion that the accused has taken a probable defense of discharge. Next part. It is the settled proposition of law that when the accused number 4 admits his signature found on exhibit P1 and 2, the presumption under section 139 of NI Act would arise. And the complainant is discharged of his initial burden. The burden shifts on the accused to rebut the presumption by probabilizing his defense. From the discussions held above, it is clear that the accused number 4 has probabilized his defense regarding discharge by producing the documents and also examining himself before the trial court. Once the accused is successful in probabilizing his defense and discharging and rebutting the legal presumption under section 139 of NI, the burden again shifts on the complainant to prove existence of legally recoverable debt. In the present case, the complainant has not discharged the said burden, and therefore the accused is entitled for acquittal. Accused number 4 is entitled for acquittal. Next part. PW1 categorically admitted that the accused number 2 and 5 admitted that he has no document to show that accused number 2 and 5 are the directors of accused number 1. He has not led any evidence to show liability of accused number 3 as well. The liability of accused number 4 as well. Sorry, accused number 3 as well. Admittedly, it was only accused number 4 who signed the checks exhibit P1 and 2 on behalf of accused number 1 company. When he is successful in rebutting the presumption under section 139 of NI, and when the complainant is not successful in proving the existence of legally recoverable debt, I am of the opinion that all the accused are entitled for acquittal. I have gone through the impugn judgment. Well, I think for me, negative dismissed. Appeal is dismissed. Yeah, I believe. ಮತ್ತೆ ಯಾವ್ದಿದೆ? ನೋಡಿ, are you ready?
Rashid, this contention is used, opponent approached the hand loan of rupees 3,50,000. In this regard, the respondent, the accused issued a PDC check. PDC checks on 21/9/2012. The PDC check bearing number 1017070868 is presented on 21.
No, check is bearing 3301.
Check.
48.
Check is 07086.
That is the check issued by the complainant.
A check issued by the not accused.
So complainant had
The complaint
hand
is
loan of rupees 3,50,000.
3,50,000.
How it was paid?
Through the check, the complaint check,
Complainant paid it through check.
through check.
When?
That is 13/8/2011.
Then
Then the complaint is demanded the repayment of the
yes.
loan amount. The accused issued PDC check in favor of the complaint.
Yen check?
PDC check, post dated check. On 21/9/2012.
ಎಲ್ಲಿದೆ ಅದೆಲ್ಲ?
Sorry?
ಅದೆಲ್ಲ ಎಲ್ಲಿದೆ? ಕಂಪ್ಲೇಂಟ್ ನಲ್ಲಂತೂ ಇಲ್ಲ.
Judgment.
Where you got all these facts?
Through the judgment. Judgment copy.
Judgment or contention ಆಗಲ್ಲ sir. Complaint ನಲ್ಲಿ nothing is stated about that.
PDC check is 070868 dated 21/9/2012. The same check was presented.
ಇದು ಹೌದೇನ್ರಿ ಅವ್ರದ್ದೇ? ಇದು ಹೌದಾ? ಅದೇ ಇವ್ರೇನೋ ಬೇರೆನೆ ಹೇಳ್ತಾ ಇದ್ದಾರೆ, ಇದ್ರಲ್ಲಿ ಫ್ಯಾಕ್ಟ್ಸ್ ಇರೋದೇ ಬೇರೆ. ಹೌದಾ? ಕರೆಕ್ಟಾ? ಎಂಟೈರ್ಲಿ ಡಿಫ್ರೆಂಟ್, ಅವ್ರ ಫ್ಯಾಕ್ಟ್ಸ್ ಹೇಳೋದೇ ಡಿಫ್ರೆಂಟ್. Criminal appeal 401 of 15. Separate.
The thing was presented by the complainant on 21/9/2012. The complaint banker issued a memo on 26/9/2012. The check is insufficient fund. Complaint issues legal notice. Accused also should reply notice to the complaint and denied the transaction. After the taking the wrong statement, that is denied the transaction. The complaint, in order to prove the case, he got examined in the PW1.
Yes.
PW1, he got marked examining
Hmm.
documents exhibit P1 to P8. After the completion of the evidence, 313 statement, the accused denied the entire statement.
Hmm.
After
What
that,
is your defense?
my defense is my lordship. Cross-examination of the PW1 is admitted that the transaction is no other transaction.
No, what is
accused.
your defense?
My defense is the check amount is already paid through the cash and with the exhibit exhibit D4, D1.
Hmm.
As per the exhibit D1, the accused paid 1 lakh rupee and he received 3 checks. That is exhibit D1, my lord. Jagdish, son of Maya, number 8, Vaisala Nagara, Silpilkatte, Magadi Raste, Vishnu Manche, Bengaluru, Adanano, Muni Krishna, that is accused, son of Narsapa, number 10, Vidakul Vishnu Manche, Bengaluru, Kumbatondo. In Nelkanda Vidasali Vasavagirva, Jagdish Adanano, Adnaru Yerdu Soda, Muru, Muni Krishna Rovarinda, Mundu Laksha Rupa Lana, Padilipene.
Yes.
And the exhibit P8 ಅಲ್ಲಿ ಮುನಿಕೃಷ್ಣ ನಾನು ದಿನಾಂಕ 16/2/2013 1 ಲಕ್ಷ ರೂಪಾಯಿಗಳನ್ನ ಜಗದೀಶ್ ಸನ್ ಆಫ್ ತಿಮ್ಮಯ್ಯ ಕುಂಕುಲ್ಕಟ್ಟೆ ಮಾಗಡಿ ರಸ್ತೆ ಬೆಂಗಳೂರು 91 ಇವರಿಗೆ ಹಿಂದಿರುಗಿಸಿದ್ದು ದಿನಾಂಕ 17/2/2013 ಬ್ಯಾಂಕ್ ಆಫ್ ಇಂಡಿಯಾ ಭರತ್ ನಗರ ಶಾಖೆ ಅಂಜನಾನಗರ ಚೆಕ್ ನಂಬರ್ 273642 ಮತ್ತು 273636 ಈ ಎರಡು ಚೆಕ್ಗಳನ್ನು ಕೆಳಕಂಡ ಸಾಕ್ಷಿಗಳ ಸಮ್ಮುಖದಲ್ಲಿ ಹಿಂಪಡೆದಿರುತ್ತೇನೆ.
Exhibit P8.
P8.
That is produced by the complainant.
Complainant.
Who is Munikrishnappa? Munikrishna?
Munikrishna is the respondent accused.
Accused.
Yes, my lord. It is stated, the complaint is stated that my lordship is received 1 lakh rupees. And he paid the complaint, the accused is paid 1 lakh rupees to the complaint as per the exhibit given. And he has to pay 2 lakhs rupees to the complaint by cash. The accused stated that he has due to amount 50,000 rupees payable to the complaint. He stated that the complaint has failed to pay the said amount. Is filed past case against to this accused, my lordship. This, my lordship, exhibit P1, his cross examination admitted that exhibit D is also admitted under the exhibit D. D is received 1 lakh from the accused, and the exhibit DW1 in his cross examination is stated that he has not received any, he has not having any transaction other than this transaction. In this, in his cross examination, he admitted that the exhibit D1, it is not mentioned that he is the amount of 1 lakh rupees he has paid in respect of is 3,50,000. The exhibit, the PW1 is in his cross examination admitted that except the check transaction, there is no other transaction between him. Between him. So the as per the complaint, there is no other transaction between the complaint and accused.
No, when exhibit P8 was marked,
Exhibit P8 is marked on 6/2, my lordship. 6/2.
through which witness,
My lordship,
through which witness,
the PW1, my lordship,
ಎಲ್ಲಿದೆ ಅದು?
PW1. Through the PW1, the exhibit P8 is marked. Respect of the transaction, the accused has paid 1
ಕೊಡಿ
lakh.
ಇದನ್ನ ಅವರಿಗೆ, ಎಲ್ಲಿದೆ ತೋರ್ಸ್. P8 ಇಲ್ಲಿ ಯಾರ ಥ್ರೂ ಮಾರ್ಕ್ ಆಗಿದೆ? ಇದೆಯಾ? ಇದೆಯಾ P8 ಮಾರ್ಕ್ ಆಗಿದೆ? ಡಾಕ್ಯುಮೆಂಟ್ ಕೇಳ್ತಾ ಇಲ್ಲ ನಾನು, ಎವಿಡೆನ್ಸ್, ಯಾರದ್ದು ಎವಿಡೆನ್ಸ್ ಅಲ್ಲಿ? ಡಾಕ್ಯುಮೆಂಟ್ ಕೇಳ್ತಾ ಇಲ್ಲ ನಾನು, ಅದ್ ಬೇಡ.
ಆ PW1 ಕಡೆಯಿಂದ
Through which witness the document was marked? Do you have the deposition of PW1? ನೋಡಿ ಎಲ್ಲಿದೆ?
cross examination.
Where there is reference to exhibit P8 ಅಷ್ಟು ತೋರಿಸಿದ್ರೆ ಸಾಕು ನನಗೆ. I do not find that.
ಪ್ರಮಾಣ ಪತ್ರದಲ್ಲಿ ಬರೆದ ವಿಷಯ ನಿಜವಾಗುತ್ತೆ. ನನಗೆ ಸೇರಿದ ಪಾಸ್ಪೋರ್ಟ್ ಅಗತ್ಯಪಡಿಸಿ ಒಂದು ದಿನಾಂಕ 11/11 ನಾನು ಒಂದು ವಿಷಯ ಆರೋಪಿಗಳಿಗೆ ಚೆಕ್ ಅಗತ್ಯಪಡಿಸಿದ್ದು ಅದನ್ನು ಮಿತಿ 2 ಆರೋಪಿ ಸಹಿ
ಬಿಡಿ, ಅದು ಇಲ್ಲಿದೆ, DW1 ಅಲ್ಲಿ ಇದೆ.
PW1 ಬ್ಯಾಂಕ್ ರಸೀದಿ 5, ಅಂಚೆ ಸ್ವೀಕೃತಿ ಪತ್ರ 6, ಆರೋಪಿ ನೀಡಿದ ಉತ್ತರ ಪ್ರತಿ ನೀತಿ 7, ಆರೋಪಿ ವಿಷಯ ಕ್ರಮ ತೆಗೆದುಕೊಳ್ಳಬೇಕೆಂದು ಹೇಳಿಕೊಂಡಿರ್ತಾರೆ. ಸ್ವೀಕೃತಿ ಪತ್ರನೇ ಆಗಿದೆ ಸರ್.
ಇನ್ನೊಂದು 10 ನಿಮಿಷ ಬೇಕು. In exhibit P8, there is no reference to exhibit P2. In exhibit P8, there is no reference to exhibit P2.
P2 ಇಲ್ಲ.
Then how you probabilized?
Exhibit P8. P8 ಅದು P7 ಗನ್ನ ಮಾರ್ಕ್ ಆಗಿದೆ ಸರ್.
Mark agide sari, there is no reference to the check exhibit P2. What is the reason assigned by the trial court to acquit you?
Regarding that exhibit P2 is not assigned by the trial court. The complaint in cross-examination stated that except this transaction, he has not other than transaction. At least he admitted that except the check, he has not obtained any other documents from the accused. The accused is evidence stated that on 16/2/2013, he has paid 1 lakh rupees to the company through the exhibit P1. And he has paid 2 lakhs rupees to the company by cash. The accused stated that he has due amount of 50,000 payable to the company, but stated that the company has failed to pay, and he has filed false case against these accused and 3,50,000 disputed check. The PW1 is cross-examination, we admitted that exhibit D1 is also admitted that exhibit D1 he had received rupees 1 lakh in the accused. The DW1 in cross-examination stated that he has not received any transaction other than transaction. So in this cross-examination, he admitted that in the exhibit D1 not mentioned that the amount of rupees 1 lakh paid received is 3,50,000. The PW1 is cross-examination is admitted that except the check transaction, there is no other transaction between him and accused. If there is no other, what the purpose in respect of the transaction is the accused has paid 1 lakh rupees to his
Application.
moreover, the accused has paid 1 lakh.
By executive, 1 minute, third learned counsel for respondent on the application under section 436 of CRPC. The accused is now in judicial custody after execution of the NBW issued against him by this court. Then counsel for the respondent submits that he continues to represent the respondent and he will address the arguments on merits. Considering the contentions taken in the application and also the submission made by the learned counsel for the respondent, the application is allowed. The accused is ordered to be released on bail, subject to condition well uphold. Condition. Then third learned counsel for the respondent on merits. When counsel for the appellant is absent, list for further hearing of list for arguments of the appellant. After that, further arguments. You could move the ಅಂದ್ರು ಬರ್ದೇ ಇದ್ರು. Counsel for the appellate.
ಸ್ವಾಮಿ. Copy will be issued, hand delivery. Submission. Copy to hand. Copy to hand delivery.
Lordship, humble submission, serial number 23. In that, my lordship, this is second time the endorsement has. Idu munchenu they have sent the same and my lordship, I humbly apologize for the same.
Inconvenience to.
I very much understand, my lordship. But much of.